Welcome back, everybody. Day 20 is in the bags, and so is the evidence phase in the trial of State versus Richard Allen. We walked in this morning, and the defense rested. After quite a long wait, we then had what struck me as a rather ill-conceived rebuttal case by the state. And that was it for the day. That was all that we had, other than the usual issue with growing line drama, changes to the courtroom proceedings, things like that. So tomorrow we are going to get the jury instructions and the closing arguments. After that, the case is delivered into the hands of the jury for their deliberation and hopefully a verdict. Hopefully a just verdict. Let's go ahead and break it down. We started with, like I said, a little bit of changes. We already knew things were going to be different yesterday because we were not allowed to line up outside the courthouse as we've been accustomed to because of the election. Apparently, there were proceedings. We were told that ballot counting was going on in the courthouse, and so for security reasons, they were keeping us at a distance from the courthouse until 7 this morning. Well, as you know, people have been starting to line up as early as the day before, so creates a lot of uncertainty as far as how the line is going to be organized, how that's going to work. Folks ultimately managed to work it out amongst themselves. We're able to put together a list of everybody who was in line so that we could track and not run into the problems we were all, I think, a little bit concerned about just people who didn't respect the process that we had tried to create and honor for all of each other. Would potentially interfere with that. But it didn't really happen. There is always changes in the line. I call it the line amoeba because it does have a tendency to shift and evolve. And that's, at every point. The count always changes. So for example, when my line setters arrived yesterday, we were number 10 in line. By the time I made it into the courtroom this morning, I was number 13. So how that happens, you are as good of a boss of judge of that as me. I don't know. But it is becoming more and more of an issue as we learned today that the public seating has now been cut back even further. I've been telling you about how the defense, for the past several days, they have lost access to their seats. There have been a few occasions where people who are there with the family or on the defense team haven't had a seat in the courtroom. On one occasion, one of the attendees had to be taken past the bar to sit there with the defense team in the well of the courtroom. One of the defense investigators had to sit outside because there was no seat. The 10 seats that had been allocated to the defense shrank to 6 and then shrank further to 5. Well, the defense seats got restored today. So that is good. Very good thing. Very much in support of that. And so they had their 10 seats restored. There were also 3 seats that were allocated to the defense team. The media's presence in the courtroom has grown from the 12 seats allocated to 15 that I counted there in the courtroom today. These are, credentialed media seats. And as a result from that, the public seating, which has previously been 24, has now been reduced to 18. So I did make it in today. Actually, I take it back. I remember the count this morning. I was number 16, number 16 in line to get in. So I did get in, but it wasn't. I'm not going to say I wasn't a little nervous about it. Today was largely long and not a lot happening. It was a lot of sitting and waiting. Put us in the perspective of what folks who serve on jury duty are, I think, often accustomed to experiencing a lot of downtime. They haven't really had that so much in this case. We haven't had large periods of time where the jury is excused and things are addressed outside their presence. There have been a couple of just short occasions like that. But I think folks who have served often have, stories about, very glad they brought a book. And it's a really good opportunity. I had somebody comment to me that it was a really good opportunity to finally force them to make their way through James Joyce's Ulysses, which is, from my perspective, very much an accomplishment. That's a book I have picked up and tried to read on more than one occasion, and just find it rather inaccessible. Brad Rosie was stylish as always. Of course he was. Today was a black suit. He wore this with one of his light blue shirts. It's like a sky blue color. Not so much the robin's egg blue that has that little bit of a green tone to it, but just a pure light sky blue. And the tie today was somewhere in the spectrum between purple and fuchsia. It was on a very cool pink side of the purple spectrum, and it had a light blue flower pattern, like small flowers that were connected with like a linear, a light blue, not like a straight hard line, a very soft organic kind of line. I couldn't get a close look at the flower. It looked a little bit like a simple 5-petal flower, something like a simple zinnia, like that. But it was another quite eye-catching tie. It really isn't my favorite color type, but it is eye-catching. It is definitely very eye-catching, and overall, not a look that I had any significant problem with. Before court was called into session, I did notice Bob Seagal, who's one of the local reporters. Bob took a lot of heat over the last couple days because he was the pool reporter who incorrectly put in his notes that Richard's daughter, Brittany, had responded that she did not love her father. And so then that mistake got picked up and got perpetuated over multiple outlets. Bob took accountability for that the same night, was very apologetic, expressed that he was hoping he would get a chance to apologize to the family. And so I saw him this morning appearing to do that. He was speaking to Kathy, who's now seated in the front row with how the seating has shifted. So he approached Kathy in the front row, and I saw him, and he had what appeared to be a very stricken, very concerned look on his face. He did appear to be very regretful for that. So I appreciate him doing that. That's it's just a very hard thing that this family has gone through as well. They have not done anything wrong. They are suffering through this entire process, and so much of it is just, it makes the situation worse for them. So something like that being widely reported, it would just be devastating. So I did appreciate seeing that Bob appeared to recognize the impact of that mistake and wanted to express his regret that had taken place. When we came into court, the very first thing that happened when court was called into session and the jury was present was that the defense rested. They did not call any further witnesses. So it appeared that they wanted to maybe take some time over the course of the evening to just think about it and see if that was, if they really were done, if there was anything else that they needed to tie up. Ultimately, they made the decision that they were not going to call any further witnesses. So contrary to, speculation and prediction and stuff like that, we obviously did not hear Rick Allen testify, and we did not hear Kathy Allen testify. Immediately after the defense rested, we had a request for a sidebar by Mr. McClelland. This sidebar was the longest one of the day. It lasted about 6 minutes. And when we returned from the sidebar, the judge informed us all that the state, there will be several witnesses still coming that are not yet available. So they would go ahead and take a recess and excuse the jury at this point in time. So the jury was taken out of the courtroom. So they didn't have to sit there at attention in their hard chairs. They could go back to whatever their jury room arrangements are in Carroll County Circuit Court. If anybody has served on jury duty in this courtroom, I would love to know what the jury accommodations are, what the jury room is like. Is it comfortable? Are there snacks? Is there a coffee machine? Presumably there's a bathroom in the room. If not, where do they use the bathroom? Those types of things. I always like to get a visual of where it is the jury is going to be spending all their time once they get into the deliberations until the point that they're hopefully able to reach a unanimous decision. After the jury was brought out, the judge announced that the court did have its potential jury instructions and that she proposed that we could settle them while we wait. So make use of the time while the witnesses are being gathered. She observed that she had received no proposed instructions at that point from either side. So that struck my attention because there was a question last night, or maybe the night before. Still losing track of time a little bit. But very recently, there was a question on here about the possibility of lesser included instructions. I was, gave that some thought. Nothing really jumped out to me off the top of my head. Thinking about it a little bit, I thought, well, maybe murder second. Maybe you could propose murder second because the state's theory is less. It comes across as less of a premeditated theory. Their story is, he had other plans for the girls before he was scared and decided sort of impulsively that he would need to kill them. And so that's potentially taking you out of the premeditated first degree murder and more into a intentional but not premeditated killing. But when it comes to lesser included instructions, there's a lot of strategic thinking that goes behind them and whether you ask for them or not. There's definitely a line of thought in some cases and with some attorneys and some defendants that it's better to go all or nothing. If the view is that the state has overcommitted, overcharged, brought something that's more excessive than they're really going to be able to prove, then it's not really to your advantage to offer the jury a compromise, to offer them something less than the worst. In a way, it's kind of just making it easier for them to do something that they may not otherwise, be inclined to do if they only have the option of the hard charge or nothing. But that also can be very risky. It just depends on the circumstances. In this particular case, I don't dispute that decision, really. The question really comes down to, I think, just did he do anything at all? Was he a perpetrator in this or was he not? The degree of culpability is not really the type of thing. This just isn't the kind of case where that's the issue that you're really going to, you're not going to argue that in your closing. Ladies and gentlemen, but, even if you think he did it, please just only find him guilty a second. No, you would not do that because it sounds like a concession. It sounds like you're saying, well, there might be reasons you should think about convicting him at all. And this defense team clearly doesn't think that. And after all of these days of evidence in this case, I'm just not sure that there's really good reason to think that either. So it is a risky decision, but it is, I think, the right one for this case. Even a murder second conviction would carry, an extended prison term. Don't know what the ranges are in Indiana, but, typically with any type of murder, you're not looking at less than something like 25 years. Not uncommon at all. I mean, that's like a floor. Not uncommon at all for that to be higher. Account for the fact that these are two charges, two victims. It has the potential to be really significant. So what are you really getting from a lesser verdict anyway. At this point, we're likely talking about the rest of Rick Allen's natural life in prison, either way. So no real advantage from requesting it, and potential for significant downside just by offering that compromise, and just the implication that, well, maybe there's something here, and that's not where the defense wants the jury's mind at this point. The judge also stated that she had prepared everything from the pattern instructions, so the form instructions that are there for Indiana courts. These are guidelines typically used. It's very common in most jurisdictions now, I think, to have pattern jury instructions like this, and it just keeps everything uniform. They're often kind of created by committee. A lot of different people have input into how the jury instructions are worded. And so it's just a way of generating consensus about how certain topics, legal principles, and things like that should be discussed, what the right language is. And you minimize the risk that way that a judge is going to say something, extremely outlandish that's going to be found to be error on appeal and cause you to have to do it all over again. So where there are pattern jury instructions, it's extremely typical for judges to stick largely with those. And then to the extent there's anything that's not in the pattern instructions, that's maybe as specific to the case, that a principle that arises from case law or something like that, it's really on the party who wants a special instruction to request it and substantiate it. So she indicated that she had not received any at that point in time. She's using largely the pattern instructions, many of which are the same as the preliminary instructions that were given at the beginning of the case. So we did hear several of those dealing with burdens of proof, what the definition of proof beyond a reasonable doubt is, things like that. Those concepts will be repeated in the closing, prior to the closing arguments. She also referenced that her pattern instructions that she was providing included instructions on the defendant not testifying, which is also standard. It's an instruction that usually advises the jury they're not allowed to draw any adverse decision and any adverse inference from the fact that the defendant has chosen not to testify. Also, an instruction that she included addressed prior inconsistent statements. I haven't looked at this specific form instruction because when I got home today, I went to sleep and I slept until about half an hour ago. So I don't know exactly what that instruction is, but my suspicion is that this is along the lines of what she had stated to the jury one of the previous trial days when the defense was impeaching a witness, and she instructs the jury they're not to consider it as substantive evidence. Prior inconsistent statements are introduced to impeach a witness's credibility. And so because of that, it is often the rule in many jurisdictions that prior inconsistent statements, they aren't substantive evidence. It means you can't consider what the prior statement is as proof that the prior statement is true. It only just goes to whether you can rely on this witness and what they are saying here in court today. So it seems like a little bit of a fine distinction, but this is really pinpointing and I think targeted towards Brad Weber, because Brad Weber's trial testimony, of course, he drove his white van to work on the 13th. He drove straight home that day. He got off at 2:02 and would have made it home at about 2:30 in the afternoon. So very important part of the timeline that the state is trying to present to line it up with Richard Allen being the perpetrator. The defense then has confronted him, several times now over a couple days with statements that he made previously to these. I think it was Sergeant Goatee. I can't remember his rank, but it was Goatee from the Hammond County Sheriff's Office, and then Special Agent Poole of the FBI, who we didn't get to hear from. And that when he did an interview with them on, I believe February the 18th or February the 19th. We kind of heard both dates, and it's not entirely clear which one it is, but just very shortly after the crimes, that he told them he had gone to service his ATM machines after work, and that's as a result, he did not go straight home after work. He got home more in the ballpark of about 3:30. So this instruction is really telling the jury, you can't consider that testimony as proof that Brad Weber did in fact go service his ATM machines that day and get home at a later time than he originally testified. You're only allowed to consider it for whether he's being dishonest in his testimony or his testimony is unreliable for some other reason. It's not always dishonesty. Prior inconsistent statements are not always dishonesty. People's memories do change over time. There can be all kinds of different circumstances that can affect why a person might have a different account of something one day than they had on a different day. So it goes to their credibility, their veracity, and the reliability of what they've said in court. And so ultimately, it's not that the jury is being asked, did Brad Weber go home at straight home from work, or did he go service the ATM machines? It's not really that kind of question. It's just Brad Weber said he went straight home after work. Can you rely on that statement in light of all of these surrounding circumstances? The state indicated they had no objection to the court's proposed instructions. Mr. Baldwin simply had a question about the instruction that the judge had provided on the defendant not testifying. They were not sure that this was a pattern instruction, and Judge Gohl acknowledged that this could be a modified instruction that she had given previously based on a prior request from the defense to, I think, provide further explanation. Mr. Baldwin said that he thought maybe they would want the pattern, but ultimately I think they just wanted some time to be able to review it, because they kind of went back and forth. The judge was like, so you don't want the modified? He's like, well, maybe it's okay. So they really did not finalize this, in part because Mr. Rosie then also indicated that he wanted to submit a proposed instruction on the juror's ability to judge the credibility of the defendant's alleged confessions. This is kind of an issue, a little bit of a unique technical issue in this case, because they are already being instructed. There's a standard pattern instruction that's given in every case that the jurors are the sole deciders of the credibility of all the witnesses in the case. The problem, though, is that Richard Allen isn't technically a witness in this case. He's never testified. And so if you wanted to get like super finicky with the rules, that rule doesn't technically encompass statements that he is alleged to have made out of court. It really just goes to the testimony and the documentation that's been admitted into evidence that reports these statements. That is all subject to credibility determinations. But you just never know if somebody wants to be real nitpicky with the language and what's allowed and what isn't. There's always a possibility that would not encompass Mr. Allen and his situation. And so he acknowledged that there has already been a determination that the court is the gatekeeper of whether the statement is voluntary and product of the defendant's free will. That decision has already been made. Judge Gohl has made that ruling. So he said he was looking at some case law to support potentially giving that instruction, but he would want to basically be able to submit something by email this evening and see if there was something that they would propose. So ultimately, it just deferred the total finalizing of the jury instructions at that point in time. Mr. McLeland responded to this as, basically there's a pattern instruction on the credibility of witnesses generally, and that's enough and that's okay, and that's all you should give, and he would object to anything else. Of course he would. So the judge just requested to please also send her, in addition to this proposed one, please also send her the pattern one on the defense, the defendant's choosing not to testify. and that they would be able to discuss that tomorrow before the instructions are finalized and read to the jury. She indicated it was her practice to break up the instructions where certain case-specific instructions are given first, then the closing arguments are held. At the conclusion of the closing arguments, she then gives general instructions on basically how to handle the evidence and how to conduct the deliberations. So she just reported that's been her practice since the last time the jury rules were modified 15 or so years ago, and neither party had any objection to proceeding in that fashion. Time-wise, she stated that they had had a previous discussion and that they were anticipating or preparing to accommodate 2 to 2.5 hours of argument per side. She said much past that, she might start to fiddle with a pin or tap a clock or something like that to get their attention. So not suggesting she's going to bring out the vaudeville hook and pull them off the stage as soon as the clock expires. She did say she recognized that there has been a lot of evidence presented in this case. It's obviously been quite long, and there is potentially a lot for them to have to go through. And she wanted both sides to have as much time as they needed to be able to present their arguments within, the realm of reason. But ultimately, 2 to 2.5 hours is a pretty long time for anybody, certainly the jury, to have to be sitting in the hard seats. And so her plan is to probably have breaks in between. The state will go first with their closing. Then we will likely take a break. When we come back, it will be the defense's closing, probably a break after that as well. And then the state's rebuttal, followed by the closing instructions, and then the case is handed to the jury. So lunch is going to fall in there somewhere, but we don't know exactly where. Don't know if they're going to have time to kind of race through the closings and then take lunch like the first two, and then take lunch and come back for rebuttal. Just kind of ultimately, I think, is going to depend on how long they take. 2 to 2.5 hours is a very long time for closing arguments. There's almost like a point of diminishing returns with a closing argument, because you just run the risk that if you aren't really tight and really focused, that you're losing the jury. If it's not real organized with what you're doing, and it's clear that there's a point for why you're continuing to talk for that long, you can run the risk that the people are just going to tune out. I think I've been trying to think back on the longest oral closing argument I ever gave. I want to say it was in the ballpark of probably approaching about 2 hours, and that was in a 2-week murder trial. So not this long, but still long. And there was a lot to talk about. There definitely was a lot to talk about. So I don't think it's going to be that difficult for either side to fill that time. The question is just going to be their ability to do that constructively and helpfully in a way that really does give the jury some structure and some guidance with how they are thinking about the case and how they are inviting the jury to think about the case. The more that they are able to do that, the more likely the argument is to land with the jury, regardless of how long it is. But ultimately, that structure and just the need for your critical points to be communicated, that's really what should drive the length of the argument, and not just whatever time the court is allocated. Not a good idea to just get up there and talk because you have the time to do so. Mr. Rosie had asked about the possibility of having the table out to be able to, I think, leave exhibits out, have them organized so that they can then be used in the course of the closing. That did suggest to me that maybe Mr. Rosie is going to be giving the closing, whereas Mr. Baldwin obviously gave the opening. We might get a closing from Mr. Rosie. But that's not a guarantee. He's kind of looked at by Judge Gohl as the lead attorney, like when they will come back from court and she'll ask them, are you ready? Things like that. She will kind of defer to Mr. Rosie for that type of thing. So he could have just made this communication on behalf of the team. Can't really say for sure. But the judge did indicate that would be fine. Her only request would be, not have stuff, like not be way up in the jury's face, give them their personal space. That's not a terrible request. So after this, we went back into recess because we're still waiting for the witnesses. So we recessed from 10 a.m. until about 10:25 a.m. The judge called the court back into session while people are still coming back in. Kathy and her family were not yet back in the courtroom. The defense team was not yet, like all of them, in the courtroom. But apparently, I guess the state, we had left it off that just the state would notify the court when their witnesses were ready and they were available to proceed. So it kind of looks like the state gave that notification, but the defense is not yet ready. In fact, at one point, Rick, they're on the record. They haven't brought in the jury yet, but they're on the record, and people are coming in, and Rick's not even there. So Rick is brought in, after the court has been called back into session. We sit there on session for a little bit, and before we're told there's no attorney there to handle cross. It's only Ms. Auger that's present in the courtroom at this point in time. So we go back off the record at about 10:31. Ms. Auger very kindly, like loud whispered that it's going to be about a half an hour, speaking to the family. So we could all get a share in that information. So 10:56, we're finally called back into session. The state is ready to proceed with their rebuttal. So the first rebuttal witness that's called by Ms. Diener is Brianne Wilbur. We heard from Brianne during the case in chief. She is one of the three girls with Rayleigh Voorhees, or four girls. It was a group of four of them. But Rayleigh Voorhees was her friend, and then Rayleigh's two sisters went on this walk with them. She had testified previously about their walk out to the High Bridge and about Snapchat photos that she had taken. She's then presented with a Snapchat photo that was taken when they were arriving at the Freedom Bridge, which is the first one that they would reach from walking from town. And so this was submitted as Exhibit 318. In response to this exhibit being offered, Mr. Baldwin asked to do some foundational questions and wanted to know when she gave this to the state. I saw when copies were provided to the defense table, Mr. Rosie turned and handed the photos to the investigator, the defense investigator, the main one. His name is Matt, I believe. And with this look on his face, and asked him, have you ever seen this before? So just another thing looks like hasn't been provided in the discovery. So asked her when she gave it to the state. She's not really sure. So he's helping her narrow down. Was it before your testimony or after? She says, no, it was before her testimony, and that it was maybe the first time that they talked when she sent Ms. Diener all of the photos. So don't know if this is going to be something that the defense is going to take issue with. They didn't object to the admission of the photo. But ultimately, what it shows is just another part of the sequence of this hike. It's time-stamped at 12:25 p.m. on February the 13th, 2017. And so it's there to really, document their arrival at the Freedom Bridge. And after that, just reiterated, they walked towards the High Bridge. She said they saw no other young girls their age or younger and no other man who resembled Bridge Guy. Mr. Baldwin handled the cross-examination. He said, you recall this was a day when school was out. Are you, you really don't remember any other kids on the trail? And she just said, not that I remember. And so he asked, is that something you would normally be looking around and watching other people and taking note mentally of things like that? And she said, no, not really, just only if there is a reason, only if there's something, noticeable to note. And as far as other people being on the trail, she just said, just really can't recall if there were any others and really can't say. Ms. Diener then redirected that she had been questioned pretty close in time to that day, and that the event of that day, the girls going missing, was what had caused it to stick out in her mind. And Mr. Baldwin then recrossed and drew out that when she spoke to police initially, their focus was at the end of the timeline, the period around 2 o'clock or so, when they were leaving the trail. And so she agreed that was really what the focus of the police had been, and mostly what they talked about. So they had asked her about the beginning part, but the end is what had stuck out to her. So that was the first rebuttal witness. It adds a piece to the timeline, but it doesn't rule out that Mr. Allen was on the trail at the same time and just simply wasn't noticeable, wasn't observed. They didn't really pay attention to him. Also, potentially that there was just, he could have gotten to the trail like with his own time frame that he's placed. He's placed, in his own words, from 12 to 1 or so. And then it's reported that his prior statements in police reports were 1 to 3 or 1:30 to 3:30. He said in his interview he didn't think that he was there. He was there for that long. So another possible interpretation of this timeline is he came and went before they got there. He came and went about the same time, but he left through a different kind of path than they would have taken, or that he arrived after they did and left before they came back to that area closer to 2 o'clock p.m. So ultimately, it's another piece of information, but not anything, it's helpful to the state, but it's not like a smoking gun or anything like that. Mr. McLeland then called Brian Harshman back to the stand. He's the Idaho State Master Trooper who listened to all of Richard Allen's phone calls and the videos. He referred to, while Mr. Allen was at Westville, he was asked a series of questions. When he was at Westville, was he in a one-man cell? Yes, he was. They're trying to come off of this language of solitary confinement and call it a one-man cell. That is the euphemism that the state wants the jury to be thinking when they're evaluating the conditions in which he was held. So while he was at Westville, he was a one-man cell. Then he was moved to Wabash. He was still in a one-man cell. Then in Cass County Jail, he's still in a one-man cell. Yes. Mr. Rosie objected to this line of questioning as being beyond the scope, that they didn't go into any of this in their direct. And Mr. McLeland just objected to say it's a rebuttal to show, because the defense has put the conditions of his confinement at issue to show that he was in relatively the same conditions throughout the course of his incarceration. I don't know that this is a win. I don't know that this is good. I mean, it seems to me that if you want to argue that the later statements were not the product of the conditions like the first ones are, that you would want the conditions to be different. But, what do I know? I'm not running the prosecution here. So making a point of saying that the conditions are the same. However, he did acknowledge that in Cass County, he has a day room that has a table and chair. His room itself is bigger square footage than where he was at in prison. He doesn't have rec time at Cass County, whereas he did have rec time at Westville, although I'm not sure how much he used it or really how pleasant it was, given how it was described as just being, a closed room with a grate on top. It's like a room that breathes, a ventilated room. And the only things in that room that we heard about were a pull-up bar and a basketball net. Also indicated that Mr. Allen had said in some of his phone calls that he would communicate with his neighbors in Westville through the walls. So they're really honestly trying to pitch this as social contact, talking with other inmates through the walls. That this is like a good thing. And that he can't do that at Cass County because there's nobody in that kind of proximity to him. Given how he reported, like what the inmates were saying to him and stuff like that, that's probably not a downgrade in his circumstances in his mind. They were calling him baby killer, telling him to kill himself. So probably not having those conversations, probably an improvement. But they just are really committed to minimizing the circumstances still that the jury's seen with their own eyes. You can try to pretty it up and call it different things, call it a one-man cell instead of solitary confinement. They saw in their own eyes, what that meant. So I don't know about the strategy of kind of bringing this back to life in your rebuttal. It seems really, really imprudent to me to close your case with this topic being the last thing that the jury is thinking about. The conditions of confinement. It does get worse. Mr. Harshman testified then that while at Westville, there had been issues with him eating paper and flushing the toilet. Mr. Rosie objected again, saying this is beyond the scope, and he was, in fact, specifically instructed to stay away from this. Yeah, he was, remember? We couldn't get into specifics about Mr. Allen when it came to his own defense experts. They couldn't offer opinions about stuff like that. The state was objecting to hearsay because his experts relied on the same reports that the prosecution relied on to make their case in front of the jury. The jury's seeing all of this stuff happen. I do. I really wonder how much of this is landing. Is that sitting well with them? Because you think and you expect the prosecution to be forthcoming. They're interested in the truth, right? So why not just put it all out there? I feel like most people kind of have the sense that if you are trying in good faith to present a fair picture for them to judge, if you're not doing that, then you don't look very trustworthy. So I wonder how much of this double standard and hypocrisy is really what it is. We can use what we want, but you can't, and we'll object to you using it, that Max Baker called them out on so effectively. Just absolutely cut him off at the knees. Mr. McClelland was complaining about the specific videos from Mr. Allen's confinement that they chose to play, and says, you didn't choose to play them anything from like a regular day. And Mr. Baker says, yeah, and as far as I can tell, you didn't either. And in fact, you had objected. I was prepared to play a lot more stuff. You didn't have to object to that, but you did. Turn that right around. They definitely noticed that one. But just as kind of an overall big picture pattern, I see it repeatedly, and I do wonder if they're seeing that as well. The judge basically ruled, that Mr. McClelland's response is essentially, well, this is rebuttal. And she says it's rebuttal and lets him do it. Well, yes, rebuttal still needs to be responsive to the defense case. That's what makes it rebuttal, and not just a reopening of direct. A reopening of your case in chief to put on new things that are not in response specifically to what the defense put on. That's what a rebuttal case is for. It's not just a catch-all. Anything I didn't get in that now I feel like putting into court, I just have a second chance to do that. Rebuttal is to respond to the defense's case. So if the defense's case didn't raise it, didn't put it at issue, then you're not supposed to be able to go there. And yeah, he was. Mr. Rosie was specifically prohibited from going into a lot of detail about Mr. Allen with his own experts. This was most notable with Dr. Gracian just yesterday, who was the expert on solitary confinement and its psychological effects. And so they weren't allowed to go into a lot of his interpretation of what he was seeing, what he was reading, and what that meant from this broader perspective of experience that he has with hundreds and hundreds of inmates who have been in solitary confinement, and understanding the types of effects that can have on a person's stability and on their behavior, on their emotions. So I thought this was a very well taken objection. The court clearly did not. So they continued that the eating paper and flushing the toilet, he didn't have any of those issues in Cass County. But there have been others, including threats to staff. At this point, Mr. Rosie objects again, and they have a sidebar. I knew exactly where this was going. They were going to try once again to get that smear video out there. The one that they had tried to present before, that they represented, was showing Mr. Allen, doing all of these aggressive. It sounds like aggressive behavior, like a tantrum type behavior in the jail. So first off, I don't know that this is really the dunk you think it is when you've just gone and established he's still pretty much in the same conditions. Like, that's the point you're trying to make. You just argued that's the point you're trying to make. So if he's in the same conditions that drove him psychotic and gave him behavioral problems before, then why would it be any surprise that he would continue to have behavioral problems? Seems like that would be pretty normal and predictable. So it was very clear where they were going. Ultimately, they came back from the sidebar. The defense objection was sustained, and she instructed the jury to disregard the comment about the threats to staff. The state concluded with Mr. Harshman at that point, and Mr. Rosie did not have any questions for him. So once again, was this particularly helpful? I don't think so. I think this was a Hail Mary, last-ditch effort to try to get that Cass County video in. It didn't work, and so it was ultimately a bust. And all they really did was just reinforce that even after Mr. Allen got out of Westville, they continued to treat him. They continued to treat him like they treat the worst of the worst inmates that they are punishing for infractions. That's the treatment he got. Well, this theme got developed even further with the state's final rebuttal witness, who was Dr. John Martin, who is the treating psychiatrist at Westville. Ms. Diener handled the direct. Mr. Martin was a challenging witness. He was clearly very nervous and very defensive. He wanted to offer all kinds of explanations and sort of long-winded answers that was causing Mr. Rosie to object because it's not responsive to the question he was being asked. He was not good at listening to the question and responding just to that. He had information that he wanted to say, and that's what he was focused on, was trying to get his information out regardless of what they're actually trying to get from him. So that just really, that stood out to me because it does come across as a very defensive type of position. He also at points had, as he would call it, presentation that struck me as really inappropriate. And I'll get into that when we get into those parts of his testimony. So Dr. Martin is familiar with Richard Allen. He was his patient at Westville. First encountered him around treated him from November of 2022 through November 2023. He was the psychiatric care provider. So his background is he received a basic medical degree from St. John's Medical College in Bangalore, India. He is an Indian man. He speaks with an Indian accent. He finished his training in 1976. His school started a psychiatry program, went into training between 1983 and 1986, to become a psychiatrist through a program at the University of Miami, Florida, which recognized his prior education, although it had not been in the United States. He became licensed as a psychiatrist in Florida in 1986. He's also licensed in Nevada, in Indiana, and in some other state that I couldn't hear what it was. He is in good standing in all states where he's licensed. He began to work at Westville in 2020, but he had a long history of working in corrections. He states that his very first full-time job was in corrections, and since 1983, nearly all of the work that he's done has been in jails and prisons in correctional settings. So he has probably about 40 to 45 years experience total, accounting all the different things that he's done during the course of his career. He explained at this point, he called himself a workaholic. And so like even when he would have a full-time job, he would take on jobs elsewhere. So he would moonlight at different things in addition to his full-time employment. And that's how he came up with the 40 to 45 years total experience, even though he's only starting from 1983, which puts him at 41 years. He started at Westville in July of 2020. At that time, he was already working at the Indiana State Prison, and he started working additional hours in the Illinois Department of Corrections. So again, this moonlighting that we're hearing about, this guy is cutting himself real thin, real thin. In February of 2022, the Westville psychiatrist retired. So he was asked if he could help, and he started to work there. This is consistent with what we heard about from Dr. Wanger, who testified that Dr. Martin originally came in when they had like a short staff, a backlog situation, and that he came in kind of part-time to help out with that. So he worked at Westville 1 day a week on Tuesdays. Then he said he did other work for Westville on Sundays, but he did not do it at Westville because everything is online in their record system. He would, at his remote office location, do record reviews and internotes and things like that at that time. At some time in November was when he first met Mr. Allen. They meet November 22nd. There's no place in the WCU for him to enter his notes, for him to like make the electronic records. He had an office at Westville, but it was over in the medical building in a different area. So away from the WCU compound where Mr. Allen was being held. He was aware that Mr. Allen had been transferred from the jail as a safekeeper, and he understood that that was because it was believed that he was in danger if he was in a population with other people. Dr. Martin was not an employee of the Department of Corrections. He worked for Centurion, so the same staffing company that also provided Dr. Walla. Given that, and given what I'm hearing and what we will hear as this goes on about the treatment that's provided, I might have a little look into Centurion. I might do a little like Pacer search, look for Centurion, any issues with them that have been litigated, because got to tell you, they don't seem to be bringing the best and the brightest or the most ethical to these prison facilities. And this goes back to our whole conversation about, follow the money, look at the privatization of various aspects of prison processes to understand why conditions are the way that they are, because a for-profit agency has a motive to cut costs. You bill the highest that you can for people that you pay the least amount that you can get away with. That's going to give you your margin. That's how you're going to make your money, by being a provider of these types of services. So in many ways, it gives them an incentive to find the bottom of the barrel. That's where they're going to be able to make the most money. He had patients all around the compound, but the safekeeper was in the WCU. His office itself was, as I said, over in the medical building. Sometimes he would have to see several people before he would be able to enter his notes into the system. So he would just jot things down on pieces of paper. and then enter them into the computer whenever he apparently got there. We never got this narrowed down from a time frame perspective. Like, would you religiously do this every day? Would you do this like on Sundays based on your chicken scratch notes? Never quite got that real nailed down. So I think that could be inferred in any possible way, really. The computer system is secure, so nobody would be able to go in and enter medical records in his name. For Mr. Allen, he was in charge of prescribing the psychotropic medications. He was aware of the prescriptions that Mr. Allen came to Westville receiving. So when he came from the diagnostic center, he came on Prozac for depression. Mr. Allen was stable at that time, so he says he continued him on that. When asked if changes in his medications would be documented, he said, well, there are notes and there's also a form called an MAR record, which is a medical administration record or medicine administration record, something like that. The nurses would keep track then of whether he was taking his medication or not. So on these records, he explained that what they would do is they would initial when they provided him the medication. And then if he did not take it, they would circle their initials. So that's their code system for medication monitoring using these records. He said that was just one way to monitor if he was taking his medications. Nurses would usually inform him about patients not taking their medications before he would ever review these records. So it's not clear that he really actually did review them all that much. The records themselves are also confidential, but anybody in the medical system there in the prison has the ability to look at those. So Ms. Diener introduced states 319 and 320. We'll start with 319. These appear to be Dr. Martin's notes. He was asked to take a look at a few pages and see if he could identify them. He sat there for about 3 to 4 minutes, flipping through like nearly every page. We're all sitting there watching him. One point, Judge Gohl, kind of is looking at Ms. Diener like, you going to do something here? Ms. Diener continues to stand and wait for him. Eventually, kind of breaks in. It's been like 4 minutes. Like sit there and wait for 4 minutes in silence, and get a sense of how long that is. Finally breaks in, asks him if these are the notes that he wrote. Yes, and there's also a consent form for Prozac. He identifies Exhibit 319 as his treatment records. I want to call out right off the bat that these records may be sealed and probably would qualify for sealing under the Indiana rules on the access to the courts that we went through the other day when we watched the video. And we're talking about why those videos were not displayed to the public and are likely going to not be made public after the end of the trial. There's specific exceptions, like basically specific categories of records that are under the rule, like categorically, like automatically exempt from being disclosed to the public. In that case, it was involving nudity and potentially sexual conduct. These particular records are medical records, and there's an exception for that in the rules as well. So very possible that these will be sealed and appropriately so. Really, it's not something that necessarily needs to be out there for everybody's consumption. The jury needs it, yes, but medical records do historically receive quite a bit of protection because they're extremely personal. Exhibit 320, likewise, probably will be sealed, but who knows? These were the MARs, the medication administration records, and they documented all the medications that he received, whether they were psych meds or just like ordinary medicines. Like, I don't know if he needed an Advil or something, it would probably be documented on one of these sheets. Mr. Rosie wanted to ask some preliminary questions about the MARs. Identified there's lots of different initials on there from lots of different people. Those people are not him. They're basically nurses on different shifts. He objects on hearsay grounds and also just to foundation that the witness lacks personal knowledge of Mr. Allen's medication status. Ms. Diener responded that it relates to his administration of the medications and the refusal, and it's a medical record. So they were both admitted, 320 over the defense objection. They didn't object to the other one, the notes, which was interesting. They didn't object to the notes, but they did object to the medication administration. Mr. Allen, he then acknowledged, entered the WCU as a safekeeper. That's been referred to in this trial and, in many settings as being in solitary confinement. So he's asked, are you familiar with the difference between being a safekeeper and in solitary confinement? So the doctor explains sometimes someone is transferred to prison because they're not safe in a jail. And so it's for their own protection that they are transferred to DOC to basically keep them alive. He says he has treated safekeepers before in general population, but he has not treated safekeepers in solitary confinement like Richard Allen was. And he notes that this solitary confinement can also be referred to as a one-man cell. He says, I say one-man cell because although it is the same room, it's the same circumstances, the same condition, solitary confinement is a term that has a punitive connotation. It suggests he's being isolated from others for breaking the rules, which is how most people end up in solitary confinement at the WCU. They're already in max. They've committed crimes. They have been convicted of their crimes. They are serving likely long prison sentences, and they break the rules in prison. They have infractions, and they are punished by being put into solitary confinement. Very interesting decision by the state to put on as their final witness somebody who is going to really crystal clear, explicitly draw that connection. It's been implied before, but to just come straight out and say, solitary confinement is usually punishment. Like that's normally what it means. So I didn't call it that. I used a euphemism because that wasn't Mr. Allen's situation. Whereas Mr. Allen, he had not done anything wrong. He hadn't broken any rules, but he was being treated as if he had. That's right. So he's clearly sympathetic in some respects, even though, like I said, he's presenting as very defensive, very nervous in this whole presentation, giving these long run-on answers. At some times, I indicated Mr. Rosie would object that his answer was non-responsive. Those were being sustained. Ms. Diener would also frequently cut him off and just start over, like with the question, and I'm going to redirect you to, this specific question of da-da-da-da-da. And so this is happening like over and over. This is kind of one of the run-on answers that he gave that Ms. Diener did not interrupt and maybe, from the state's perspective, probably should have. He says, well, in a way, the fact that Mr. Allen hadn't done anything wrong, but was being treated as if he had, then in a way, that's not right. But on the other hand, they also had to consider the responsibility that the prison had to keep him safe. And so even though there's a serious risk to mental health from solitary confinement, the need to keep him safe was the overriding consideration. He was familiar with solitary confinement. Nearly every prison he's ever worked in has had several people in solitary. For 1 year when he was in Florida, he supervised all solitary confinement detainees. During the course of Mr. Allen's confinement, he says they had all kinds of meetings with the warden, with psychologists, with a lawyer from the Department of Corrections to see what they could do to make life a little bit more comfortable for Rick. Things like giving him access to a tablet, to a TV, phone calls, rec times, and things like that. Asked if he had a suicide companion. now, get the euphemism here, right? Now it's really becoming clear. He had a suicide companion as well. They're pitching this like this is a perk that they gave him, like the euphemism companion, like this is a friend of his, when it's a spy. It's a spy they're placing outside the door to document everything that he says and does. Well, he's already under camera, but those cameras don't have audio. They can't capture his words. So they have somebody sitting out there to capture his words, to spy on anything he might say in his cell. That's the companion. Was that really supposed to make him more comfortable? He also had a suicide companion. Yeah, he said he had times of expressing suicidal ideation, times where he tried to hurt, self-harm. At those times, he would be put on suicide watch. He would be given a suicide gown, suicide blanket, sheets would be taken, etc. He would have contact with medical or with Dr. Walla, with him. Sometimes he would see Rick outside of his cell. Sometimes he would see him in his cell. He starts to kind of get tangential with his speaking. Every time when he went out for rec or to make phone calls to Kathy, and he just kind of breaks off, Mr. Rosie interrupts at this point in time to ask some foundational questions. He's talking about recording and whether he had knowledge that Mr. Allen's visits with him were recorded. So he starts to stammer over this answer about every time and when he went out and this. So Mr. Rosie stops him. Says, you met with him 18 times. That's what was previously reported to him. I know that he just says that, I know that these things were done, but he never reviewed the in-cell video, never reviewed any of the transport video. He just saw him being recorded. Mr. Rosie objected that he has no foundation to testify to these things because he never even saw it. And Ms. Diener said, well, he's familiar with the circumstances of his housing and the objection is overruled. Now, it's very clear the doctor should not be able to testify to stuff that is outside his personal knowledge, unless it's the type of thing that medical professionals would ordinarily rely on in the course of providing medical treatment. So there's none of that foundation in, but it doesn't matter. They're going to let him go down this road. They turned to his initial assessment of Mr. Allen. This was in November of 2022. The first time he saw Rick face-to-face was on November the 8th. He had recently come in from the reception center, and the doctor had reviewed his records from there the Sunday before. He asked some questions for his own records, did a mini status exam he described, and said that Rick was stable. He had a history of depression and anxiety, but he didn't appear to be suffering actively from those conditions at the time. The next time he saw him was on November the 29th, and at that point, he seemed fine. Next time he saw him after that was on January the 24th. At that time, he needed him to sign a consent form for his medication, which they try to get one time a year. He started to go off on a tangent on this, but he was kind of allowed to do it. He wants to be sure that we know that informed consent is really important for them in psychiatry in particular. You get informed consent every time you prescribe. And he had that ongoing prescription for Prozac. So on January the 24th, he said, everything is fine up to this point. Everything's fine. Everything's fine with Mr. Allen. The normal time for his next visit, since he seemed to be doing well, would be, first he said every 6 weeks, and then he changed that to every 3 months. So his next visit to Rick was going to be sometime in April because he was doing fine in January. So he did, in fact, see him in April, but it was not because it was his regularly scheduled visit. It's because he got a call prompting an unplanned visit on April the 13th of 2023. Rick was still in the WCU. So he went and had some observations. He looked into Rick's cell where he was housed, saw that he was lying naked on a mattress. At this point in time, Mr. Rosie objects because Ms. Diener has handed him the medical notes and he is just reading from them. So Mr. Rosie objects. This is improper refreshment. He needs to not read from his notes. So he's advised, doctor, you can't read. You need to just remind yourself and then testify without reading. So doctor continues, he had feces smeared on him. He had brownish fluid coming from his mouth, was told he had been eating feces. I said I needed to talk to him. So the officers took him to a shower stall, hosed him down, gave him a new suicide gown, and brought him to the nurse's office. I believe this is, this video, this transport video is going to be one of the things that was shown to the jury. So they may very well have seen this entire encounter. Said he tried to assess him there. His presentation was different from in January. My conclusion is that he was psychotic. So to treat psychosis, I have to give an antipsychotic. But from interviewing him, and then he shifts again. He says, I was looking for two things. He didn't have the capacity to do the informed consent form. He can't sign off on receiving an antipsychotic. So he's looking for, to determine if he could, he's looking for insight and judgment. He describes insight as, does a person have a fair understanding of the situation and the circumstances that they're in? And judgment, is he capable of making a right decision that is in his best interest? He found that Rick's insight was deficient and his judgment was impaired, so he could not consent. They have a backup system in prison to be able to give them medication without their consent. So he chose to administer Haldol, an antipsychotic. Haldol, he says, comes in three forms. There's an oral tablet, a short-acting injection, and a long-acting preparation that lasts for up to 1 month. So after seeing him on the 13th and feeling that he was not competent to decide about medication, he called up the regional psychiatrist for Centurion, explained his findings, and that he needed to call an emergency meeting to get the authority to get him these medications. So that meeting happened the very next day. He presented to the committee. On the committee included two other psychiatrists who are not directly involved in Mr. Allen's treatment, but who are, psychiatrists, as well as Dr. Walla. All of them agreed that he was psychotic. So on April 14th, agreed he was psychotic. Not sure that's what Dr. Walla's notes said, but remember, they were like suspicious, but we need to wait and see if it lasts before we can diagnose him. And so anyway, they agreed that because of his presentation, he could be given involuntary medication. So there's a form in the records that's dated April the 14th of 2023. That's the day after he saw him on the 13th. They have the meeting minutes on them. Also includes the findings, what would happen if he wasn't medicated, like the risks if he wasn't medicated, possible other treatments, and things like that. Typically, if you're going to administer something involuntarily, you have to show that there is no lesser alternative, something less intrusive, less invasive that can be done to address the situation. Like, I don't know, maybe moving him out of solitary. But that's not a psychiatric treatment, right? Psychiatrics is just about meds, So second page of that document established the criteria to receive the medication and that they were met in this case. The treatment review committee concurred with the administration of the Haldol and the basis for the decision. The committee made the decision about him meeting the criteria. He says, I present the case, they review it, and everyone was in agreement. There's all kinds of, like, through this, he's going off on tangents. I have just taken down like the parts that were like the key to the story, because he keeps trying to run off in other directions. Ms. Diener is bringing him back. Mr. Rosie is objecting to non-responsive. He keeps talking even when there is an objection, and like he will continue to talk. I mentioned the other day that this was something that Dr. Warren did as well. The difference in that case is that Dr. Warren would sort of just talk out the objection. And it wasn't an objection that was being stated. It was just Mr. Luttrell trying to interrupt him and kind of get him going in a different direction. He would ignore that and just continue to answer his question. This was a little bit different because there would be an objection and the parties are like trying to talk about the objection, and he's still talking, and they would have to tell him, "Doctor, you need to stop talking." Really, really just like so nervous, so trying to get out what he has in mind is the stuff that he wants the jury to hear. So a lot of this is going on in this part of the conversation, and they move to what he actually did administration wise. And he's trying to give like a big, long explanation. Let me give you some background. Like, no, don't give us the background. Answer the question. So he explains the minimal amount he's allowed to explain. I want to make sure he's not going to have an adverse reaction. So I gave him short acting Haldol. I gave him 5 milligrams once a day. The maximum dose for Haldol is 100 milligrams. So he considered this a low dose of Haldol. Daily injections were given the 14th, the 15th, the 16th, and the 17th. At that point, he had not experienced any side effects. So the doctor decided to then give him the long acting. And he asked for what I could not tell was either 15 or 50 milligrams. He says the maximum dose for this is 450. So it is still a relatively low dose, but the medication is spread out over 30 days. So because of that, he was getting less than 2 milligrams a day. So that would seem to be 50. So less than he was giving him previously to evaluate the side effects. He was given the long-term injection on April the 18th. Then at that time he was still psychotic. And then the next time he saw him was a week later on April 25th. He says at that time he was still psychotic, but he had some improvement. Continuing in this to, ramble and go into side things, trying to explain more than he's being asked. Says basically on the 13th is when he was at the height of his psychosis. And so after that, he showed slight improvement with the short acting. On 425, there was improvement. He'd been asked in what aspects, and he goes on this, this tangent, this background tangent. So in what aspects did he show improvement? Well, there was no evidence of feces smearing. So that's good. Wasn't feces smearing. Said he recognized a doctor, referred to him as doctor. He didn't know the date, but he knew that he was in prison. He was oriented to his person and to his situation, but he was not very communicative. He was asking for his wife and he was asking for the warden. He was showing some improvement in his speech. He was basically more coherent compared to what he was displaying on April 13th. At that time, he was having hallucinations. He was talking to voices that he had in his head, and he didn't see any of that continuing to happen on April the 25th. He was eating at least some of his meals. He was apparently sleeping better. He was expressing some concern about his hygiene and maybe needing to shower. Again, no longer smearing or eating feces. And that he had some sadness, but it was situational. Meaning this isn't his depression. This is just, situational. He's in prison. He's sad. Next, on May 2nd of 2023 is the next time we saw him, another week later. At that time, he was lying on the mattress. He was covered in the suicide blanket. Described him as coherent. He had no looseness of associations. He denied hallucinations. There was no evidence by May 2nd of 2023 that he could see of psychosis. And went next on May the 8th. At that point, he was still wearing the suicide gown. He was coherent, denied hallucinations, but he was sad. The logs, the monitoring logs showed that he was getting sleep. He was eating some, but not all of his meals. He had been meeting with Dr. Walla. The doctor says he knew that he would not take his Haldol regularly if it was given to him. So I gave him a larger dose than I would have done. I didn't really understand this because we're on the long acting now. Like, it's not his choice whether he would take it or not. And what does that have to do with the dosage? I don't know. Sounds like there's something in the records that shows dosage being adjusted, and this is apparently his explanation. Well, it was his fault, right? His fault, because he wouldn't take it, even though he's getting shot. He's getting shot. It's not up to him whether he's taking it. On May 8th, he doesn't show signs or symptoms of psychosis. The next visit is on May 18th. There is no evidence of psychosis. He's continuing to read from his notes, and so Mr. Rosie is now continuing to object to this being improper refreshing. So here's where the behavior, I think, it just struck me as very inappropriate that this happens. Ms. Diener goes up and just says, "Doctor, because he's already been admonished about this and he's continuing to read. So she just, tells him, Doctor, I'm going to go ahead and, oh, did I say Idaho State Police again? Sorry, Indiana. Indiana State Police. I see ISP in my notes and my mind just goes there. Ms. Diener goes up to him and is like, Doctor, I'm just, going to take away these notes, so that after you read them, you can refresh. And then I'm just going to take away so we don't have this issue with reading them. And the doctor just thinks this is the funniest thing ever. He's just laughing. This is just the funniest thing. And given the context here and what we're talking about, it was so inappropriate to me. Really, really rubbed me the wrong way. We're talking about this guy who's been suffering in solitary that the jury has seen on the videos that you never bothered to watch. The jury has seen this. We've heard all about this. And you're up here giggling like a school child because you think it's funny that she's taking away your notes so that you can't read them. That just strikes you as really hilarious. I will account for the fact that he may have been very nervous for reasons that may become clear momentarily. But he did this repeatedly. It was like a joke to him when they would take away the notes. He would just laugh. He would just laugh and giggle. So the next visit he had was on May the 30th. At that point, there was no evidence of psychosis. He was eating meals. According to the doctor, he was oriented to time, place, person. His speech was coherent. He was about, at that point, to meet with Dr. Walla and had spoken to his wife on the phone. And at this point, everything was fine. On June the 20th is his next visit. At that point, he says there is no evidence of psychosis. So at this point, he decided to stop the medications. He had received a shot a few days before, but he ordered no more after that. The shot he had received before was the same very low dose. June 20th, he had just received a shot a few days before. Remember what the doctor just testified to earlier in his testimony about how important informed consent was? And yet, according to him, Richard Allen is starting to be just fine, no signs of psychosis, as of May 18th. He's just fine now, but you're still giving him involuntary medication. Any evaluation of his insight and judgment at that point in time and his capacity to be able to consent to that on his own? Might be a little bit why the doctor is nervous about discussing his administration of the Haldol. He's saying it fixed him. He's perfectly fine, like almost immediately within a couple of weeks, and yet they continue the involuntary medication up into June. When, by his account, on June 20th, his speech is coherent, he's not tangential, there's no hallucinations, there's nothing. And at this point, he's been out of psychosis for 7 weeks. Maybe this is why the doctor is a little bit nervous. Says he isn't sure if he would have told Mr. Allen that he was discontinuing the medication at that point in time. He did at that meeting, according to the doctor, he said something to me. He was not under any pressure. He spoke of his own free will, and he said, I would like to apologize to the families of his victims. And he said, specifically, he said his victims, not the victims. I would like to apologize to the families of, he means my victims. After discontinuing the Haldol, he continued to see Richard Allen after for the Prozac. Gave a little bit more background on the Haldol. It's an antipsychotic. And so when people have psychosis, they might hear voices. They might lose contact with reality. There's non-responsive objections at this point because he's been asked, what does the Haldol do? So he says the purpose of the antipsychotic is to get the contact with reality back. And so after he received the medications, he was no longer displaying those symptoms. Previous testimony had asked about other potential causes of psychosis, whether it was caused by illicit drugs. Probably not in this case because he's under such intense monitoring and security. Anything that he receives is going through that door slot. Asked if it was caused by medication problems. Mr. Rosie objected to this, that there was no evidence. Nobody had ever testified in any way about medication problems, that people had talked about medical conditions being an underlying cause of delirium, and that he had been screened for that. And then the defense expert had testified he was looking, Dr. Gracian, that he was looking for delirium. He had concerns about that because of the eating and smearing the feces and not eating and not sleeping, that these would create risks of infection that could cause delirium. So that objection ultimately was sustained. Yes, that is what the prior testimony was. It had nothing to do with the medication. And so she then asked Prozac. The Prozac he was on, that played no role in his psychosis, either the taking the Prozac or the refusing the Prozac. And as far as what Prozac is, that is the brand name. Fluoxetine is the like technical name. That's like the name of the compound. It comes as a generic form, and that's what they administer because it's cheaper. Didn't ask him about that with Haldol, but I can, confidently say that very likely one of the reasons he chooses Haldol to prescribe patients as an antipsychotic is because it's enormously cheap. It is not a new generation antipsychotic that comes with a lot lower risk of side effects, because those tend to be very expensive to administer. So very common when you see people in involuntary treatment settings, Haldol is administered because it's very cheap and there is a long history of using it. So the side effects are known and they are significant, sometimes very substantial and life-altering. But they're at least understood, so we can monitor them. We've been using them for a long time. They give them what's cheap, not what's good, what's cutting edge, what works, what's cheap, even if it might ruin your life forever. We had our lunch break at this point in time before Mr. Rosie's cross-examination. So I did have a line sitter there, and I was number 11 in line. Guys, hold on for just a second. I'm going to just pause real quickly here to go and grab my water. All right, I'm back. Just left it over on the counter by accident, and I still need it. Still working on my hydration here. This cross-examination was flurry. We call this combo punching. A lot of different angles taken, a lot of different points drawn out. The doctor really was kind of presenting as like submissive in many ways to Mr. Rosie. He was not the kind of witness who's going to fight back or be argumentative or anything like that. He was fairly passive and compliant and admitted a lot of the stuff that Mr. Rosie brought out. So the first thing is that he does not have a traditional bachelor's degree. He has this medical training from the school he went to in Bangalore, India. He had many different jobs in Florida that he describes as, 10 to 20 to 30, like first 10 to 20, 30 years of his career, that these are in different counties, different facilities. Acknowledged he had been terminated from a job in Florida, and that he'd been involved in a lawsuit involving individuals in solitary confinement in Florida. He starts to kind of resist this a little bit, but then Mr. Rosie reminds him, this is what you testified about this in your direct. So I think what he's referring to is a period, he referred to there being a period where for 1 year he supervised all of the detainees in Florida who were in solitary confinement. Apparently there's a lawsuit related to that. I got another little note on my list of things to look up for kind of these, side issues to follow up on. I would be very interested in taking a look at that lawsuit and getting a sense of what those conditions were and what his involvement was. So yes, he did acknowledge that after being reminded by Mr. Rosie, you brought this up in your direct. Oh yeah, that's right. That was a lawsuit. And Mr. Rosie had the name of it and everything. Ms. Diener at this point asks for a sidebar. They come back from the sidebar and her objection, whatever it is overruled. He confirms that the doctor gave his deposition in early October. At that point, he acknowledged that it is very difficult to treat someone in solitary confinement. At the time that he went to Westville in 2022, he was also working in another state. He said that in his direct that he was working in Illinois. So he's commuting pretty big distances and so forth to work multiple jobs. He also admitted there was a significant backlog that he had reported somewhere in the ballpark of 200 or 250 or so inmates that were backlogged when he first went to Westville, and that was part of why he was brought on in the first place. So we then he then turned to the serious mental illness. He asked him for, if his understanding of the definition was someone with major mental illness. Ms. Diener objected to this, wanted to ask some foundational questions. Are you familiar with the Department of Corrections definition of serious mental illness that was effective in 2022 to 2023? And the doctor starts to answer, I know generally, and she objects in front of him and says, don't answer. Jury's seeing this. Don't answer. Don't answer that, doctor. Don't tell them what you actually know. So then Mr. Rosie follows up. Did you tell me in the deposition that the DOC definition included someone with a serious mental illness? And he said yes. And serious mental illnesses are things like schizophrenia, bipolar, major depression. Yes. We already know Rick Allen came in with a major depression diagnosis. He agrees that solitary confinement can cause the onset of serious mental illness. It can exacerbate existing mental illness. There were times when Rick was in Westville, when he was in psychosis. He acknowledges that people can move in and out of psychosis. His contact with Rick consisted of 18 occasions between November 22nd and November of 2022 and November of 2023. The longest meeting they ever had was a half an hour, and that was his November assessment. At that point in time, there were 2 officers present. Some meetings were had at the door of the cell. So some of these 18 were at the door of the cell. And yes, he would agree those were much shorter than half an hour. They're probably minutes. Probably the literally look in, how you doing, that we heard about from Dr. Walla. The other providers, much shorter than half an hour. Between January 2024 and April 13th of 2023, he had no contact with Rick whatsoever. If he was suffering any type of crisis, Dr. Walla's notes would be a better source of information about that. Asked if she had more contact with him. He kind of gives, one of his explanatory answers. The state objects. He tries to re-ask it. Did she have more contact with him? And he's like mumbling and stuttering. The state objects that it's asked and answered, and it's sustained. Remember just yesterday when the judge is nailing down Dr. Warren, it's a yes or no question, doctor. You need to answer yes or no. Doesn't apply when it's the defense asking a question that they're not getting a yes or no answer to. Did she have more contact? Yes or no? Different rules for different people. He conceded that just meeting with Rick Allen at the door cell, the door to the cell, that was enough contact for him. That was all he needed for his purposes. Agreed that he never watched the in-cell or camcorder videos of Rick. On April the 13th of 2023, he was very psychotic. There's an objection at this point to, is there a record? Mr. Rosie says, I'm asking him a question, so I don't know what the objection is. The judge says, well, the objection is that there is no record. Sustained. That's not an objection. How is that an objection? Where is that in the rules of evidence? Where's that in the common law? Objection, there's no medical record. You can ask him about stuff that's not in the medical record. So then Mr. Rosie clarifies. He's reading from the deposition. Did you tell me you got a call on April the 13th and he was in a psychotic state? Here, the objection is that Mr. Rosie originally misspoke and said May 13th. That's why she got upset about that there's no record. It's clear to me what he's talking about. I understood. He's very psychotic. You already said that. So now Mr. Rosie's like, I'm going to impeach him. And Ms. Diener objects. He didn't ask him that before. He asked him about 513. And this is sustained. And so Mr. Rosie is just like, I'll move on. This is pointless. We already know. You got the call on April the 13th that he was in a psychotic state because you hadn't seen him for 3 months at that point in time. He was given 3 different forms of Haldol during his stay. On the 14th through the 17th of April, he received the short-term administration. On the 18th, he received the long-term. On May 18th, he received the long-term. And on June 16th, he received the long-term. Both of those, notably after, according to Dr. Martin's notes, everything was fine. He's all better. But no continued evaluation of his ability to consent to receive those medications. He says you admit that you administer antipsychotics to someone who is psychotic. Yeah. Okay. Once again, you're saying he's not psychotic in your notes, but you're continuing to administer antipsychotics. Which one is it? Acknowledge that Richard Allen suffered from major depressive disorder, that circumstances in prison can exacerbate that. Those circumstances include the separation from his family, the belief that one is being treated unfairly, his treatment by other inmates. He then said you questioned his behaviors and the timing with the meeting that he had with his lawyers. Ms. Diener objects to this as outside the scope of direct, and that is sustained. So Mr. Rosie rephrases, you expressed concern about Richard Allen meeting with his lawyers, but you don't know what they talked about. And he said, oh, no. And any opinion about that would be speculation. And he agreed with that. And it says he reported to Dr. Walla that he thought one of his lawyers was a good cop, one was a bad cop. And so he was paranoid. He had paranoia. He had paranoia about his own lawyers. He couldn't even trust his own lawyers because of this whole situation. One's a good cop and one's a bad cop, and they're both cops. And he was paranoid about them. Didn't know if he could trust them. There was an objection that called for hearsay, but it was after it was already out, so I don't believe it was even really ruled on. He noted that Rick's weight loss was significant, over 50 pounds. He says that is not normal, that people tend to gain weight in those circumstances in solitary, where you're stuck in a cell all day and you can't exercise unless you entertain yourself, apparently, by running in your cell and singing, "Mamas, don't let your babies grow up to be cowboys." Yeah, people normally put on weight in prison, period, because the food is terrible and you can't be active. You can't be super active. Asked if he'd ever treated a pretrial detainee with no criminal history in prison before, and he said yes. And Mr. Rosie asked, "Well, do you remember our conversation from before?" Ms. Diener objects to this. It's not relevant to Richard Allen. And the judge said, "Well, that's not what he testified to. He said that he did that. He did treat pretrial detainees." And Mr. Rosie said, "That's not what he told me in his deposition, so I am going to impeach him." So the objection was overruled. And asked if he thought that was appropriate. Ms. Diener renews her objection. He's there for safekeeping. It's not in his control whether he's being held there or not. So his opinion about it is irrelevant. Mr. Rosie says we've had testimony that solitary is damaging to the brain. The judge says limit it to Mr. Allen, so that's sustained. So we don't get to talk about, once again, we don't get to talk about, generally speaking, how these conditions affect people. We can only talk about Mr. Allen specifically. So he acknowledged that, yes, Mr. Allen's circumstances were unique as far as being a safekeeper held in the WCU. Acknowledged at the time he was working for both the Indiana State Penitentiary and Westville. Is that what, did I say Idaho State Penitentiary? Did I do that before? Indiana State Penitentiary and Westville. He was conducting business from his Indiana State Penitentiary computer for inmates at Westville, including prescribing medications while he was not present. So doing his prescriptions off-site. There was an objection that there's lots of questions in there that was sustained. So Mr. Rosie just broke it up. And he says, yes, on occasion, he would prescribe medications from this off-site location. Mr. Allen was a safekeeper and asked about, do you know, why he was there? He says, to my knowledge, there's an objection at this point by Ms. Diener. Are you involved in safekeeping? No. So there's an objection. Mr. Rosie says, well, he early testified to his opinion about Rick's status. The objection is sustained. Doesn't get to cross him on that. So he says, what facts are you aware of that Richard Allen had threats to safety before he arrived at Westville? So the basis for the safekeeping order is what he's trying to get into. He says, well, no indication that he was a threat to himself, not aware of someone specific being threatening, but just in general, someone thought he was, and there was an objection at this point to speculation, and that was sustained. So they don't even know. They don't even have, there's no specific incident, no specific threat. Just, we kind of think he won't be safe in there. So we put him in max. Would have been nice to have some information, something specific. I will tell you, there's a lot of, people have a lot of ideas about safety in prison, and it's very true that prison and jail can be very dangerous places. But people are held in jail with, the kinds of crimes, the kinds of accusations that you would think are the kinds of things that normally would put a little bit of a target on you, make you a threat to safety. And these people are held in gin pop all the time. That is not at all unusual. And so often there will be specific threats, or there will be an incident. If they get removed, somebody beats them up, somebody threatens them, somebody pushes them around, someone takes their lunch tray. There's typically an escalation with something like that. I'm definitely not saying that if you think he's unsafe, you should put him in gin pop and wait until something bad happens. That's not what I'm getting at. I'm just saying that that is kind of the default. They put him in and see if something bad happens. And if it doesn't, then he's fine. And so in and of itself, these things that are like, well, generally you might think a person would be unsafe because of the nature of the accusations. And frankly, even in prison, after they've been convicted of the thing, when it's not even an accusation. Because in jail, when people are being held pretrial, they can explain, and they often do, I didn't do it. Here's the circumstances. Here's what happens. If information about their charges gets out. And, I've heard about stuff like that a lot. In prison, you've actually been convicted of something. You've got the sheet. And even in prison, there are a lot of people with the kind of convictions that you're thinking of as putting a target on somebody's back in a prison setting. A lot of people have those convictions, and they're in prison and they're in general population. So this generalizing is pretty problematic in that respect. It would have been helpful to know if there is some specific reason, because otherwise it just looks like, once again, we're kind of treating him differently than we treat everybody else. And we're treating him unusually harshly compared to how we treat everybody else, because we're putting him in this unit that is normally designated for the worst of the worst offenders who have done something wrong while being confined. They've broken the rules. But for him, it's just a one-man cell because he hasn't done anything wrong. But yeah, that's pretty unfair because he's being treated pretty much the same as they are. And so to have no real specific reason, I sure hope there was, and that this doctor just didn't know it. But he seemed to think this was just generally something might happen. Well, yeah, a meteor might hit the Earth tomorrow and end all life on the planet. It might happen. Are we living our lives in accordance with that possibility? No, we're living our lives the way that we ordinarily do, going about our days, assuming that tomorrow the sun is going to come up and civilization is still going to be intact, and we're going to be able to continue as we always have. He's asked in November of 2022, when you met him, he did not have lawyers assigned at that point. And he says he doesn't know. Did you ask? No, he did not. He did not ask. And in his deposition, he apparently acknowledged that what he did on November 22nd was conduct an interview, not a formal psychiatric assessment. This is information they are taking down for the appellate record because it goes to what the purpose of this conversation was and whether this was a violation of Rick's right to counsel, because he has now been charged with a crime. Once you are charged with a crime, you have a right to counsel, and you cannot be questioned about a crime outside of the presence of your attorney. You can't be questioned about that. So, seeming here to make a record about this interview, potentially maybe being something other other than just a medical evaluation, psychiatric evaluation, without any regard for whether he had an attorney or whether an attorney should be present, by this man who is acting, this doctor who's acting as an agent for the state. Doctor says he had some background information before he met Rick, that was based on his interaction with people at the RDC. He knew that that there would be reports, and so he reviewed those reports before meeting him. And so in his November 22nd report, Mr. Allen had stated that he used alcohol socially, and he says yes. So once again, we have a discrepancy with the information that he is reporting when he is in his psychotic state, that he's been alcoholic on and off starting in 2011 or 29 or whatever it was, this very kind of illogical thing that he'd been alcoholic multiple times. Like, that's just, alcoholism is a continuing condition. Once an alcoholic, you are always an alcoholic. It's just whether you are in recovery or not. Very different account than he reported initially. Asked if there is a difference between solitary confinement and being in a one-man cell, he says the place is the same thing. He just reiterates the solitary confinement has this punitive connotation, but Mr. Allen had not done anything wrong. And he acknowledged, could that be even more confusing for someone who had done nothing wrong? And he says, yes, that could be more confusing. Why you're here when you've done nothing wrong? And this is the place for the worst of the worst people who have done wrong things. I can see that getting on your mental health. Asked if the circumstances were extremely uncomfortable, he says, well, I would not say the circumstances were extremely uncomfortable. Not extremely uncomfortable. They just drove him psychotic. But no, they weren't extremely uncomfortable because everyone was involved, was trying to make sure that Richard Allen was more comfortable, and he's starting to spew off the names of the people, and he names Warden Gallipo. And Mr. Rosie interjects, you're saying Gallipo tried to make Mr. Allen more comfortable? I mean, we saw this man testify. Well, it's prison. It's an adjustment. That was Warden Gallipo's attitude that we watched. That reptilian man that was like, literally, I was waiting for the V forked tongue to come out of his mouth. The man with like nothing going on behind the surface. Yeah, we saw that. Yeah, it's prison. Oh yeah, Dr. Gallipo and Dr. this and Dr. that and these other people, and he's spitting out the names. I didn't write them all down. Basically, the people that were in the multidisciplinary team meetings, they all tried ways to try to make him more comfortable. Two of these names that he provided, Dr. Mays and Dr. Bonner, these I understand to be people on this multidisciplinary team that would meet. Had they ever interacted with Richard Allen personally? No, he wasn't ever present when they did. And in fact, they're not even on site at Westville. So people opining about having ways to make him more comfortable who have apparently never been there, never seen what conditions he's in. And so because he's a safekeeper, basically the job of the institution was to keep him alive. That's what that's the standard. That's where the bar was. As long as he's alive, they're doing their job. And the doctor's like, well, it just wasn't safe where he was, so they transferred him to the Department of Corrections, and then we had the responsibility, da-da-da-da-da. All right, then Mr. Rosie comes in with the kill shot. On June the 20th of 2023, you reported in your notes that Richard Allen was oriented to person, place, time. He was coherent and lucid. And that day he said he wanted to apologize to the families. Yes, he reiterates this is in his notes. Earlier in the trial, Exhibit DDD was admitted. That shows a video of a transport video on at the Department of Corrections on June 20th at 10:52 a.m. I'd like to play it for you. So the state, trying to interfere. Wait, we want to verify the date. So Mr. Rosie goes ahead and walks over the master sheet. Here you go. Here it is, June 20th. They look at that. Then they go over to their own little laptop where Steve Mullen, he's the exhibit manager guy. Find that one. So they pull it up, and they sit there and they look at it and, watch it for a little bit. And then ultimately yes, confirm that's the date and time. That's when it was. So then there's an objection. He wants to play about 8 minutes of it. And now they're objecting. Well, it's one that you skipped through. The judge actually brings this up, not the state. According to Jody's notes, this is a video that you skipped through. And Mr. Rosie says, we sped it up on various occasions, but we played the entire thing. And they did. They didn't stop it and fast forward it or something like that, skip parts. The judge is trying to be well, this hasn't been previously published. Yeah, it had. They just had it on, sped up at certain points. So they bring the screen, turn it, and this time the audience can see it. Now, Ms. Diener goes and stands in front of the screen, blocking the audience from the screen. So it's hard for me to see. I have to try to look around her. The video does move quite a bit. So sometimes if Rick is higher up in the screen visually, I can see much more clearly. Other times if he's down low, I can't necessarily see as clearly. And so what we see is that in this video, Rick is in a medical room, looks like an examination room. He is in a confinement chair. He is strapped into a chair. He is in handcuffs, and he is just having a vacant stare. And it's just there's a couple guards around him. The doctor is talking to him, talking in the room, various points going around and doing things to him. He's completely unresponsive. He is, from my observation, basically catatonic. He's not verbal. He's not responsive. There's one point where he's, staring off like this. And at one point, he rolls his head forward. And it's kind of like this now. He's catatonic. Not responsive to anything. At one point, Ms. Diener walks out of the way and says, "I think we've seen enough." Mr. Rosie said, "I asked to show 8 minutes so I can question the doctor about his conditions, and I think that's fair." And he doesn't stop the video, and it continues to play, and the judge doesn't say anything. So she then moves back to where she was in front of the screen. I can see at one point Rick's legs kind of shift. The doctor is in front of him. He's doing various examinations. I see him doing stomach palpitations. I don't know if the leg movement is like that thing where they tap your knee with the hammer. Because I don't see any other real movement by Rick at all, other than this head roll and just moving his head, remaining in this catatonic state. He's not looking at anybody. Then at one point, he's completely slumped down, his head down. Basically, if the restraints were not holding him, he would have pitched forward into his own lap and maybe fallen out of the chair. He's completely limp, slumped. While this video is playing, Rick has turned his head away. He's not going to watch this video. His head is turned away. At one point, he closes his eyes, and at one point, he just, he doesn't watch the video. Kathy, sitting in the front row, she has her head down. She's not going to watch the video. Because I'm watching the video, I'm not watching the jury watch the video this time. I'm trying to watch the video itself. So I don't know what their reaction was to this. I don't know if they were, continuing to do what they had seemed to do in the past with the checking in on Kathy, looking at her, seeing if she's okay. And so we watched this for, probably about 5 minutes. I described in my notes, this is the 1,000-yard stare. The 1,000-yard stare. It's not there. Vacant. So after somewhere in the, ballpark, 5, 6, 7 minutes, something, the judge asked them to approach and they sidebar. And that's clearly she's decided we've seen enough now. And so now Mr. Rosie asks, is that the same Richard Allen you said was oriented to person, place, and time? Yes. Yes, that's the same one. Believe the notes or believe your own eyes. It's what the jury's going to have to decide. Ms. Diener then had a redirect. She asked if his interactions at the cell with Mr. Allen were recorded, and the doctor asked if he could review his notes. He is now still laughing. He's still, even after what we just watched, he's still laughing about this funny thing about how he has to review the notes and then hand them back so he doesn't read them. This is still just hilarious to him. He says the conversation he had on June the 20th, it occurred outside the cell, and that Rick was communicative. He said he would have to be communicative in order to determine his orientation to time, place, and location. Time, place, and person. And that would involve asking him questions and receiving answers. As far as the statement that he made about apologizing to the families, he didn't ask him anything. It was voluntary. There were 2 officers there. It was a product of his free will. He doesn't remember if it was recorded. If he was outside his cell, it was recorded. If it wasn't recorded, why is that one not recorded? If it wasn't recorded, how come? Because we were told every time he's taken out of his cell, they document it with that camcorder. This was an out-of-cell visit. Guards were present. He says he does remember whenever he was removed from the cell, he would be recorded. And it's a whole process, involved moving him in, moving him back. And he's trying to give all kinds of detail about, the moving him in and moving him back because, the rest of what he needs to talk about seems to be making him pretty uncomfortable. On June 20th, 2023, he reports that he interviewed Rick in an interview cell, and he was set to meet with Dr. Walla next. And so he'd already been moved by the time that he got there. He thought that his interaction that he had with Rick was very different than how we just saw him on this video. Any explanation for why his behavior is different? He doesn't want to speculate. And she says, no, we don't want you to speculate. He says, I have no explanation. He said it did not change his own recollection or change his belief in the records that he wrote. Rick had existing depression and anxiety, and that was his baseline as far as the doctor was concerned. So you don't actually have to fix those things as long as you get him back to a baseline state of just having major depression. That's his treatment obligation. So he saw the need for antipsychotics, and then once the need was gone, he discontinued them. Asked if Richard Allen returned to baseline in your care. There is a very long pause. Yes. As to May the 2nd, as to the psychosis. And then his depression was back to baseline. So he's thinking about this real hard. And he can't just give a simple answer. Did he go back to baseline? Yes. No, he's got to like break it up, but then like answer the parts separately. He was no longer psychotic on May the 2nd, but the Haldol was continued. Why was that? He's like, well, there's a lot to that. And she says, just give us the brief answer. And he laughs at that. He laughs at that because that's really funny. This whole, situation is really funny. He says, I wanted to make sure there wasn't a recurrence. So it was after 7 weeks that he observed no psychosis, that he discontinued it. After 7 weeks where he saw him 2 times over that entire period and didn't watch any of the incel video, didn't watch any of the transport video, that's his explanation. Just wanted to make sure there was no recurrence. And he was never asked if he was ever contacted after that regarding Mr. Allen being back in a psychotic state. Mr. Rosie objects to hearsay that is sustained. But she is able to elicit that he never had to come back to the facility to see Richard Allen like he had in April of 2023. Mr. Rosie has his recross. You say he spoke spontaneously on June the 20th. Did you see anything in that video that suggests he could communicate spontaneously? And the doctor said, well, nothing said he couldn't. So Mr. Rosie asked him again, did you see anything in that video that suggests he could communicate spontaneously? Ms. Dieter now objects to asked and answered, and it's sustained. Yes or no question that he didn't answer. Different rules when it comes to Dr. Warren than when it comes to Dr. Martin. Did that video, seeing that video, make you reconsider your assessment that he was no longer psychotic in June of 2022? His answer, yes. No further questions. What a terrible, terrible rebuttal case. You were better off putting on nothing. You just put this guy on the stand who looks like he is squirming because he knows he's complicit in what happened to Mr. Allen. And he wants to he's like so eager to make excuses and explain everything and give you all the reasons for why it was okay. Remember the cognitive dissonance tell when you have 100,000 reasons for everything because reality is in conflict with your perception, your view of your self-image or your view of how you want the world to be. That's cognitive dissonance. And you'll come up with a million different explanations for why you're okay. It's a defensive mechanism to protect that self-image and that view of reality. So he just comes across as this squirrely guy. And now we can't trust his notes. Because we saw with our own eyes. We saw Rick Allen on June 20th with our own eyes in the state that he was in at that time. And he was catatonic. We had several jury questions, as I'm sure you can imagine. Did the Haldol continue to be a part of Mr. Allen's medications after June 20th of 2023? He said he wants to review the medical record and confirmed, yes, it was. This is probably when he was put on the oral dose. So it will be there in the records. The jury will have those, but we don't know what they say. What time did you meet with Richard Allen on June the 20th of 2023? He answers early in the morning, and I don't remember. And he tells like the long story. I'd go see him because I'd have other patients to see, and I would go see him before I would go see the patients in the rest of the compound, is the general gist of his answer. So basically trying to suggest earlier in the morning he was alert and responsive, and I guess only became catatonic, afterwards. Based on the video of June 20th of 2023, could that behavior be consistent with feigning? And he says no. Ms. Diener asks, is there anything about that behavior that's indicative of psychosis? And he goes, no. And he's starting to explain. And Ms. Diener says, that's all. And cuts him off. Doesn't let him complete his answer. Question, is it possible for Richard Allen to slip in and out of psychosis in a 24-hour period? The answer, yes. And that's the last of the evidence. State has no rebuttal witnesses after that. The defense has no surrebuttal. So the judge advises the jury, now heard all of the evidence. The next step is going to be to give you the instructions and the closing arguments. So we are going to call it a day for the day. And the jury is now out of the room. And that's how the state's case ended. Reminding him of those conditions of confinement. It's possible to slip in and out of psychosis during a 24-hour period. Reconsidered his opinion about signs of psychosis. He wasn't allowed to answer that question. When Dr. Gracier testified, I believe it was him, he talked about the negative symptoms of psychosis. And those were things like no emotion, flat emotion, not responsive, the slow cognitive processes, things like that. He called those negative symptoms. So it does make me wonder if maybe that's where the doctor was going to go. But nope, that's enough. That's it. That's all we want you to hear. To a jury question. They clearly want to know. And the state is getting in the way of that. Really wonder how they feel about that. That's how the state closed their case. Don't hear any more. Don't hear any more about this. Unbelievable lack of judgment from my perspective. My bet for rebuttal was going to be on Melissa Oberg, that you would bring Melissa Oberg back to respond to Dr. Warren's critiques of her documentation. For example, there had been this whole issue about you didn't document any subclass characteristics for the extractor or the what he was calling the barrel hood, the chamber casing, whatever the other name was now. And Dr. Warren, keeps saying, well, that's because there's no documentation to show she ever evaluated it. To my money was on bring her back on. Yeah, I evaluated these for subclass characteristics. No, I didn't see any subclass characteristics. And, potentially just reiterate, respond to his. Well, he's just looking at my pictures. He didn't do the examination that I did when my work was reviewed. They looked at what I looked at, not just some photograph. Something like that. That's what I would expect for rebuttal, that you do it with something strong. The first two witnesses, seemingly pointless, didn't really get anything material out of that. I suppose we narrowed the time frame for the girls being on the bridge, but they've even acknowledged that even if we can't fit Rick and his walk there in that time frame, which does fit in the time frame he gave in his interview, the possibility that they just didn't see him, didn't pay attention to him because he's not notable. He's not a notable guy. He's just another person walking on the trail on a really nice day on his phone. And we know that there were other people because she told us that that was why the bridge guy stood out, because Rayleigh Voorhees was saying hi to all the people they passed on the trail. And this guy didn't say hi back. He seemed unfriendly. And that's what caught their attention. So we know that there were other people. They just didn't specifically notice them. Nothing from that. Harshman seems really counterintuitive to me. You kept him in the same conditions even after you moved him out of Westville. You made sure he was in another solitary unit in Wabash, and then you made sure he was in a solitary cell at Cass County. Doesn't really seem to be supporting the point that I think you're wanting to make, which is that, okay, even if we can attribute this early confession to psychosis caused by the stress of his circumstances, the later ones, he'd been moved out of those circumstances. Well, yeah, but he's still in freaking solitary. And now he's 150 miles away from his family and his lawyers. Very counterintuitive. And then Dr. Martin is a train wreck. Dr. Martin is a train wreck. He knows he's scrambling. And he comes across that way. You want to see what, a guilty person talking looks like? This is what it looks like. When they're just so eager to get everything out. I really don't know what they were thinking. I don't know what they were thinking. I don't know what their strategy was. No rebuttal would have been better than this rebuttal. But this is what we got. And that's, I guess, what happens when the state just absolutely has to have the last word at all costs and doesn't really give any thought to the content, the substance of the words that they're trying to get in last. We had a short conversation at this point because Mr. Rosie had apparently over the lunch been able to email his proposed instruction. It had already been sent to the state. So they had a discussion about that. Mr. Rosie said that he offered it because it goes to the jury being the judge of the credibility of the statements that he made, the incriminating statements reported by the state's witnesses. There is apparently a case that addresses this. He says the pattern instruction involves just the credibility of witnesses, but this is a different situation. And so we should basically get the advantage of this language in being able to explain and address his incriminating statements with the jury. McClellan responds that he's objecting to it. There's already an instruction on credibility, and he's looked over the case, and that he thinks there's more to the instruction from that case than is being proposed. That there was language in that case saying that the court had found previously that the confession was voluntary and admissible. And so if the court was going to allow the instruction, they'd ask that they give the whole thing, include that language, presumably about the court's finding. And so Mr. Rosie at that point said, just never mind, we'll move to withdraw it. So they'll take the existing credibility instruction and work with that. As far as the pattern instruction regarding the defendant not testifying, the defense has now decided that they would prefer the one that the court had proposed. So that is the one that's going to be given. The court then reiterated that we will take breaks after the state's argument, after the defense's first, and then the timing of lunch is just going to depend on how it plays out. So If the state's done by like, if they start instructions at 9, the instructions, if it's just like case specific ones, might take 15 minutes, maybe 20 minutes. If Mr. McLeland takes his whole 2.5 hour, that's going to take us till noon. But it sounds like his rebuttal is going to have to come out of that time allocation. So if he wants to save time for a rebuttal, he needs to do that. So maybe 2 hours. Now we're before noon. And then the question becomes, do we just plug through the defense argument, or do we take a break for like a restroom break and then come back and plug through and then take lunch? It's all very unclear how this is going to work, which is, part of contributing to the chaos about, arranging for line sitting and when, and, just all of that. The fact that none of this is really planned or organized, and we're all just kind of shuffling to try to respond to that as best as we can on the fly without access to our devices. Mr. Baldwin then responds that they have 3 brief offers of proof. So he starts with they had intended to call 2 inmates to testify, James Haas and James Newcastle. These are going to the third-party culprit defense. The judge kind of cuts him off at this point and says, I never signed transport orders for those. And he's like, well, okay, that's fine. McLeland objects at this point. He says, this isn't, part of their case in chief. They've rested. They should do it then. His objection for now is kind of just ignored. But his implication is that if they didn't raise it at the end of their case in chief, that they've waived it. Mr. Baldwin moves on. He says, Elvis Fields has been properly served with a subpoena to appear. And he hasn't. He didn't appear. Didn't show up. And so he wants a bench warrant. He wants a warrant for the arrest to bring Mr. Fields into court for violating the court order. Mr. McLeland says, well, my understanding is that an arrest warrant under the circumstances like they're asking for, it's in an order to appear and testify, but they've already rested their case. So I don't know, we'd be doing an arrest warrant in this case. So Mr. Baldwin explains there is abundant case law that an offer of proof can be done at any time. It's not based on the timing of your presentation of your case. It can be done at any time. He says we had rested so that the jury isn't being bothered by having to take on these offers of proof that they can't be present for. So they would have had much longer periods of having to be excused from the courtroom while this is going on, especially if, as they're talking about here, they're going to be calling witnesses and taking testimony. So they went ahead and rested so that the jury would not have that. And so that is what Mr. Fields needs to be here for. He wants to be able to put him on the stand to question him for an offer of proof. Says, had he shown up at all, I would have communicated to him about when to appear to do that, but he ignored the order, so that didn't happen. And the judge says, well, an offer of proof is supposed to be an offer. You need to tell me what is he going to say? What was he going to say? And Mr. Baldwin's like, well, she's like, is it going to be any different than the testimony he gave in the earlier hearing? And Mr. Baldwin's like, well, I was going to put him on the stand, and I don't know if it was going to be any different. He could have potentially changed his story. He could have said, yes, I remember this now. He could have said, yes, I do know Brad Holder. Like, there could have been different changes that we don't know because I was precluded from being able to call him in the first place. And the judge says, well, you have to know what the witness is going to say to make an offer of proof. And Mr. Baldwin's saying, well, but if he says something different, it's on him. It's not about what I say he says. It's about, it's about what he actually says. And he says, but we're going in circles because you're asking me. The judge says, we're going in circles because you're asking me to issue a warrant for someone I said is not allowed to testify because there's no nexus with the third party culprit so that, that could testify. And Mr. Baldwin is responding that, well, if he had testified, it's possible that he would have opened doors and then we would have known from his testimony and potentially been able to follow up on that. So that is why they wanted to bring him in on the offer of proof. They wanted to just basically have another shot at him to see if his story stayed consistent with the previous time. And if it didn't, did that potentially open doors for the third-party culprit to be admissible? Now, of course, as we know, from my perspective, it would not matter at all what Elvis Fields had to say. He could show up with the bloody knives, and they would say there's no direct evidence, because that's pretty much the standard she set here. A nexus requires direct evidence, more than mere speculation, more than mere proximity. And the guy confessed to the crime multiple times, implicated himself, made very incriminating statements. Hard to find a more direct connection than that. But in any event, the judge just says, you've made your record. You've made your record. And that was the conclusion of the hearing today. So that's what we got. It was not a super long one, but meaty in a way that really should not have been, from the standpoint of this being the state's rebuttal case, and it overall not leaving the impression of being very favorable for the state or a really good place to leave the jury under that primacy and recency principle. The last thing that they've heard now is this reminder about how terrible Rick's condition was in prison, to the extent that we even watched another one of the videos. So with that, guys, let's go ahead and take a look at your questions and comments. Jennifer Ferguson, what would you suggest someone do if they are ever in a place that the police ask them to come forward if they were there that day? This case is scary. It is scary, right? And I hate to have to say, think about it, bring a lawyer. But I mean, I guess maybe know your police department, and that if there's sketchy stuff like this in your police department, and frankly, to some degree or another, there probably is, because there's people like this in every police department. There's always bad eggs. They acknowledge that. There's always bad eggs, even in really good police departments. I speak very highly of the Walla Walla Police Department. That was, I was where I, did the bulk of my my trial defense career. Had very high opinion of that police department, but they had bad eggs. They had bad eggs. They had real problem officers. Every place has them. People want to help, but you got to put your own safety and your own security first. It's very unfortunate, but I am just going to go ahead and say the quiet part out loud. Things that a lot of people listening may not want to hear, but this is something Black people have known for centuries. You can't go to the police for help. They've known that for centuries. And this is why. Maybe it's time the rest of us realize that. It's very sad. And it's not how I want things to be. But how can we, after watching this, say that we should feel safe coming forward and volunteering ourselves to provide information that they can then twist and distort and use to try to gin up a case against us? Which is what this clearly appears to me to be. With all the dishonesty, all of the scrambling at the very last minute to try to come up with a theory of the case, because all you had at the time you arrested Rick Allen, you had misrepresentations about what he said and did in his interview, and you had this magic bullet that's based off of junk science. Sufficient agreement. When you apply the objective standard, doesn't work, doesn't match. Couldn't even exclude the other firearms, but didn't mention that part. That's what they arrested him on. And the case has been built off of what they got by torturing him in prison And then what they scrambled to find 2 months before trial, when they went back to Brad Weber, who'd given inconsistent statements about his whereabouts, and got him to go back to his first version of events. Yeah, that looks to me like a frame job. Mm-hmm. So yeah, it's sad that the rest of us, have to become aware of this, but that's equality, isn't it? That's equality, because Black people have known this for centuries. Melissa Hill, can you explain the aux cord thing again and the significance? The guy who rebutted it came from the state. Yes. So what happened? This was yesterday, and this was the defense's final witness, Stacey Eldridge. She was their cell phone forensic analyst. She testified to finding a line of code in the phone that indicated that at 5:45 p.m. on February the 13th, the phone registered a code that showed a wired headset, a wired headphone had been plugged into the headphone jack. And she testified that this could potentially also be equivalent to like an aux cord, like to connect it to your car or something like that. It would be that same type of jack, that same type of hardwiring. I think she maybe wasn't sure if it would distinguish between a wired headphone and an aux cable like that. But specifically, the code indicated a wired headphone. And then at 10 something that same evening, like 10:30ish that same evening, registered another code showing that the headphone had been unplugged. And so that was what we can understand to be the evidence supporting the claim the defense made in their opening statement that they would present proof that after the girls are supposed to have been killed, supposed to have been left there abandoned. Rick Allen is gone because he had to be out of there, by 4:00 if he's the muddy, bloody guy on the road that Sarah Carbaugh saw. Human hands touched the phone. That's what they said in opening. Human hands handled the phone. And yeah, you would have to handle the phone to plug headphones in and to unplug them again 5 hours later. And there's really no there's certainly no explanation for that piece of information in the state's theory of the case. There's no reasonable explanation. That's why Mr. McClelland had to resort to asking these just bizarre questions about, well, what if somebody moved the body and unplugged in the headphone? Would it register? Really? Is that our theory? Because what would the purpose of that be? So that was the evidence that came from the defense. The state expert then the defense had called back Christopher Cecil and Brian Bunner. Those were the two Indiana State Police cell phone forensic analysts. Mr. Cecil did the far more in-depth evaluation of the phone. Mr. Bunner is who did the initial extractions and did the handling of it that caused data to be lost. So it was Christopher Cecil who was asked then, after being called by the defense, to just clarify that he did not know what this code meant. He had seen it, but didn't know it. He's deferring to the defense's expert about what that means. Mr. McClelland then asks him about the possibility that that could be the result of water or dirt getting into the headphone jack. And he said, well, I went out to the hall. I had an opportunity to do some research during the break. Had an opportunity to do some research out in the hall. And that research, it consisted of a Google search. His research out in the hall ascertained that that dirt or water can sometimes cause the phone to register as if a headphone is plugged in. So then when he's on cross-examination, Miss O'Shea, she is very, very, she's pretty fired up about, you did a Google search. What were the results? What were the sites that you looked at? He's like, oh, well, they were like troubleshooting forums like on Apple and stuff like that. We talked about this last night. These are user forums. These aren't talking about the Knowledge C database. An Apple forum, that's Apple troubleshooting forum is like the thing that people get on because you're trying to plug in your headphones and listening to your music and you're not getting any sound, or your sound is crackling or something like that. So you go on the forum and you Google and you troubleshoot. Why aren't my headphones working? I dropped my phone in the pool. Now my headphones don't work, So never even got like really nailed down that these are forensic related sites he looked at. These are Google results. So she really lit him up on her redirect on that, and it was a flaying. She filleted him with that, with the Google search. They've had 7.5 years to look at this phone and to figure it out. He knew that it was there. It was in his report. He just had a little footnote on it that, well, the research on this isn't complete, and so I don't know what it means. And that was 2 years ago. Apparently never updated it, never got caught up on the research because the defense expert did. Says, yeah, now we know what these codes are. Sounds like we kind of knew at the time. We just weren't like definitively sure, needed to do more study. So we suspected at the time this was a wired headphone. And yet somehow that doesn't get brought up in the state's case, right? Just one of these other things. We're just gonna bury our heads in the sand, pretend it's not there, not get out ahead of it. So that was how that went down. It was a Google search. Fashion Chick 24. I meant to ask last night, but ran out of time. Would the data logs for the phone show if someone put it in airplane mode? I know airplane mode would stop any communication or tracking of data. Thanks. Yes, she testified that the logs would show if the phone was placed in airplane mode. However, these are part of the power on off logs, or at least related to that. And so they are things that it was information that was lost due to the handling of the phone. So it could have been, but because of how they handled the phone, that information is lost, and we will probably now never know. Jennifer Ferguson, do you plan to come back for retrial if the jury hangs? If I am available, I would be back. Yep. See their second try. Not Turtle. Hi, as an attorney, would you, as someone that's witnessed this firsthand, give your opinion on what to expect the jury may find guilty, not guilty? As an attorney, what I can tell you is that you can never predict what a jury is going to do, and you never really know what the jury considers to be significant. We in Washington, we have the opportunity, typically after a trial is concluded and a verdict's been returned, we have the opportunity to speak with the jurors if they are amenable to that. We can't force them to talk to us, but lots of times people are willing, especially like when you're a young lawyer and you're still learning and stuff like that. They tend to be very helpful with that type of thing. And so it's very common to talk to jurors about what were the things that made the most impact on your decision in the trial. And it will often be things that you don't really understand how that fits in. Because you're not part of the deliberation, and the deliberation is like a collective thought process that you're not a part of. When you pull out parts of that thought process, it may not seem very, very sensible to the outside. So it's just very, very hard to predict because the thought process is not what you expect it to be, and it's hard to predict the outcome. I will tell you, when the jury came in this morning, I did notice what seemed to be a couple of very distinctive differences in demeanor. I saw that some folks appeared to be talking with each other and laughing, like when we're on these breaks in the sidebar while the jury is sitting there waiting and stuff. And others of the jury just appear very solemn, very solemn. And so I don't know, is that indicative of anything? I don't know. My prediction, I don't think there's going to be a guilty verdict. I feel fairly comfortable with that prediction. My impression is that particularly those videos of his treatment, they just made too much of an impact on the jury. It was very, very influential. And I just have to think that's going to call into question the statements that he made while he was in that state. And the fact that the defense has had these experts that have come in and explained how that works and why it works. And that this is honestly kind of predictable, kind of textbook, according to Dr. Gracian, who's seen hundreds of cases. To me, I think there's a good chance that at least with some members of the jury, the confessions are severely undermined. And as far as the rest of the case, there just isn't a very good case. There's just not much there. He doesn't match the descriptions. He doesn't match the descriptions of the witnesses who say they saw Bridge Guy. They say he's very tall, muscular, young. It's not Rick Allen. It's not him. His car's not there where they say it's supposed to be. Betsy Allen says that's not his car. That's like a 1965 Mercury looking car. There's just not much of a case there without the confessions. And that's why so much of the case, I think, has always been built on the confessions. That's why they were so important. And that's why it raises questions about, was that really the goal of all of this? Is that why you treated him the way that you punish the worst of the worst offenders who are committing infractions in prison? Because this is not something they just learned yesterday about the effects of solitary confinement. It's not something they just learned yesterday about psychosis. It's not something they just learned yesterday about false memory. All the things that we've heard in the course of this trial. So I feel fairly confident predicting I don't think they're going to get a conviction. It really comes down to, is it an acquittal or will the jury hang? And I don't know. I believe there should be an acquittal. As a practical matter, it may just depend on the split. If they go in and start off their deliberations and there's a strong split, 6-6, then I think there's a greater likelihood that you don't resolve it. Because it's just there's pressure back and forth both ways. Both people, both sides, so to speak, have supporters that can help reinforce them, keep them motivated, keep their morale up, that type of thing. If it's a narrower split, 9-3, 10-2, it's harder to hold up in the face of all that opposition. So that's about as far as I'm comfortable predicting. Just given my trial experience, you never know. You never know what a jury is going to do. I've had cases where, I remember one victory I had, I was honestly kind of shocked I got it. I really was. I was shocked. I've talked about this case before. This guy was a convicted sex offender. From his youth. He was like 14 years old when he got convicted. He's now like in his 30s or something like that, late 20s, 30s. When you have that type of conviction, it tends to have pretty significant downsides on your prospects in life. You don't go very far. And so this guy was, he was homeless and he had to register. And so they had specific rules for registration when you're homeless. Basically, you would have to go in regularly and report where you were sleeping, basically. So this guy was going in and reporting regularly that he was sleeping, under this bench, at this park, at this bus stop, whatever. He eventually according to him, is told that basically, unless he, leaves the area or picks up somewhere permanent or is being outside of like one of his usual spots, that he doesn't need to go in and continue to tell them that. So he doesn't. And then about 6 months go by, and then the registration officers decide, oh, he's not coming in to register. It's time to go arrest him and charge him with failure to register. So failure to register, it's a strict liability offense. It's not something that you just have to have knowledge of your duty to register, pretty much. And as long as you have knowledge of your duty to register, then, if you don't, you're going to be convicted. So it's a fairly straightforward crime. And, I had to put the guy on the stand to testify, to tell his story about this is what was happening, and this is what I was told, and this is how it went. And I was very nervous about doing that because even though I've met this guy and he seems, he's not a crazy person. He's not a bad person. He's not angry. Like he doesn't come across like Brad Weber. I'll just put it that way. Presented very well on the stand. You're still nervous. Anybody with that kind of background. Jury believed him. And they acquitted him. So it's not that I didn't think he didn't deserve it. I just really, I didn't think that they would give him that grace to say, I believe this guy and not the people that are in charge of the record keeping. But they did. So I didn't expect that one. You just never know. InfoNurse, how is it that RA's statements made out of court are not considered hearsay? They are not hearsay when the state offers them, when they are offered by a party opponent and they are admissions, meaning there is like something incriminating about them. That is an exception to the hearsay rule. So the state gets to put in his statements saying, I did it, and the defense does not get to put in his statements saying, I'm innocent. That's the rules. Tell me if you think that makes sense. Stephanie, any of your trials on the web so we can see you in action? So not my trials. I've never been in a televised trial. There's nothing like that out there. I am out there on the web for oral arguments that I've done in the Court of Appeals and in the Washington Supreme Court. I've actually posted those links a couple times on my Twitter, but they're probably way back and you might have to like scroll or do an advanced search or something like that to find them. But the Washington Supreme Court website, if you just trying to think of how to do it, the website that publishes the oral arguments is called TVW, and it's like a public service broadcasting network in Washington. So they cover Supreme Court hearings, Court of Appeals hearings. You would just have to know like the date that I do an argument. I actually have one coming up in December. I think it's on December the 4th. It might be the 5th. Not totally sure. But so I'll be in action for that. You can watch that when it's. I don't think they post those ones live in the Court of Appeals. That might be a watch back after the fact. But it's up there, and I'm up there for several others. The most recent one was in the Supreme Court last fall. That's not the last one I did. It's just the last one I kind of remember is because that one was one I posted a link to because people ask me this, from time to time, can we see you in action? So I had posted a link to that one. And it is always kind of cool. It's the Supreme Court. Like I've been in front of the Supreme Court several times now. I haven't counted 6, 7, 8, something like that. And it does get easier every time, but it's a very different vibe from the Court of Appeals because the Court of Appeals, you're arguing to 3 judges, and the Supreme Court, you're arguing to 9. And so it's this very imposing scene with these 9, extremely intelligent people staring you down, ready to grill you about your case. So that was the last one that went up in the Supreme Court was last fall. And it is somewhere on my Twitter. And it's on TVW, and it is a case that I ultimately ended up winning that argument. So that's what's out there, but nothing, unfortunately, of me in trial. Shy Gal 8, who do you think should do closing for the defendant? I'm kind of stuck on this one. I go back and forth. Mr. Baldwin has that emotive skill, that connection skill that really does make me want to give him the football. But he has been exhausted by this trial. I mean, you can just tell how much it has taken out of him. It's been so stressful. It's been so aggravating. It's been so unfair. It's just been so unfair. And I guess I just worry that he might not be on his A game. Mr. Rosie is an extremely skilled lawyer. He's good at making his points. He expresses things very clearly, very cleanly. He's organized in how he presents things. So it would be one or the other of those for me. Not that I don't think Ms. Auger would do a perfectly good job, but just in terms of the kind of presence that I think you want, I really would prefer that special quality that Mr. Baldwin has. But I just don't know, with all that this trial has taken out of him after all this time, that he'd be able to bring that at the A level. And so given just how much there is to sort through here, how important it is for the jury to understand real clearly, systematically, what the defendant's case is and why, I'm probably at this point handing the football to Mr. Rosie. Because I think he's going to be able to do that. He's going to be able to express the outrage. He can definitely express the outrage about Rick's treatment and this case and the dishonesty. And we've seen that from him. The trick is not overdoing it. It's got to be appropriate. It can't be universal. You got to modulate that kind of thing. But I think he can do that. He's a very, very skilled attorney. Sarcasm FF. Andrea, thank you. You're in their home stretch. We are indeed. Would love a collab on the civil family lawsuit on this case with Omar Serrato, the tilted lawyer on YouTube. You're amazing. I don't know about a civil or family lawsuit in this case. I mean, possibly there will be a civil case. I've definitely brought that up, like whether he's convicted or not. The treatment, the conditions, the violation of the policy on apparently multiple grounds, with the consequences that it had. It seems like that's pretty good grounds for a lawsuit. But, if he files one, I'll definitely pay attention to that. Summertime. Did the ME establish a fairly solid time of death for each girl? Absolutely not. The closest the medical examiner got to a time of death, as he said, we can't really get any closer than sometime between the time period when they disappeared and when they were discovered the next day. That's as close as they gave us. It seems quite odd to me that they can't get any more specific than that, just based on, some type of estimate based on things like, had lividity set in, what state of rigor are we in? They talked about how the blood pools, these large pools of blood, were still congealing. That sounds pretty recent. I mean, think about you cut yourself, you have a scab. How long does it take to scab over? Even like a really deep cut, does it take more than a couple hours? I'm sure there's probably different things involved when you're talking about, blood that is outside of a body, that is on a ground and stuff like that. But that really caught my attention. It was still coagulating. But no, the medical examiner did not narrow it down at all. How does that match up with the state's timeline? The state's anything. The state's timeline can be anything within the time frame as far as the time of death goes. They would not give us anything more precise. Thanks again for everything, Andrea. You are very, very welcome. Thank you all for your support. Sentient Dreamer. Isn't one man's cell an acknowledgement of guilt of torture from solitary confinement? That's a great point. Consciousness of guilt. When defendants try to use clever words to minimize what they've done, we say that's consciousness of guilt. I think that's a really good point. Let's spin how awful we treated Richard Allen. Judge Gold set all that up. Yeah, she did. Yeah, she did. She didn't sign the original safekeeping order. Judge Diener did, and it was a very bizarre order. That might be one thing that's worth. I'm going to make a note of that too. I just have all of these notes of things that I'm like, just because there's been so much to this case, and all these details, stuff that happened pre-trial, things that I haven't talked about on my channel. So I've been really, giving some heavy thought to maybe let's explore some of this stuff, like over on my Substack. But that safekeeping order, it's one of the most bizarre pieces of judicial writing I have ever seen. I mean, it's not judicial temperament wise. It's just bizarre, where he's blaming the public and the interest, and just, it's wild. So he entered the original safekeeping order. Judge Gold presided over the hearing to modify it when the defense moved to modify it, have him released to a local county jail like Allen County or Cass County. And Judge Gold did not, my understanding did not allow those videos that the jury saw today to be played. So never watched the videos to see what the conditions were, and nevertheless produced findings that the defense's claims were exaggerated or not true, and that Richard Allen received better treatment than other inmates in the WCU at Westville. So just bought hook, line, and sinker that line that Warden Gallipo came in with his little lizard-like demeanor. He received better treatment than the people who are being punished for infractions after having been convicted of serious felonies. Oh, he received better treatment from them. That's just unbelievable. So that was the role she played in all of that. Mary Walters, in 9/22, I wrote on how my ex was bridge guy, how he was in a group that films people getting hurt and has a cell tower simulator. I was arrested for this. Oh, yeah, there's apparently not much of a First Amendment here in Carroll County. Apparently not much of a First Amendment. People have the right to talk about their theories. People have the right to talk about their observations. People have the right to talk about their opinions, and people have a lot of rights to talk about what's going on in court proceedings and police investigations, because these are government processes. And we are the ultimate overseers of our own government. That's pretty much the reason why we have the First Amendment in the first place, so that we can be free to criticize it. I've heard a lot of stories, Turtle Boy-esque, for those of you over following the Karen Reed case, who are watching this same type of phenomenon, where people expressing their opinions is being treated as harassment and witness intimidation. So I am very sorry that you went through that. That seems like something that you had every right to say, and you should not have been arrested for it. And it might be worth talking to somebody who does what they call Section 1983 lawsuits. That's the type of lawsuit where you are suing police, law enforcement for violating your civil rights. It's worth talking to somebody about that. It's a very specialized area of the law. So I'm definitely, not wanting to say opinion-wise, you've got something or you don't. But if you came into my office and told me the story, I would refer you. I would encourage you to talk to somebody and see if they could give you some guidance. My dog is my ears. Thank you, Andrea. Line sitters. Thank you very much to the line sitters. I have come back to when live ends, no subtitles. But yesterday, does Weber fill ATMs with money? They transport money in strong box here. Does he use similar block signal? That's a good question. So I have the videos set up to create subtitles. I've been told there have been some issues with it. I already know that they don't get finalized until after the live is over. So if you're with us live, you're not going to be able to get the subtitles. They should show up afterwards. People have reported some issues with that with me. I've gone in and checked the settings and stuff. It should be set up for subtitles. So they should be working. If there is something that's not working, it's on YouTube's end and hopefully will get fixed. So I did want to just mention that. He did not say anything about transporting them in like a blocked, signal or anything like that. He testified basically he would go to the bank. He would just go to whatever bank branch was nearby. He does this, he said he doesn't usually do it in his van. He does it in a Subaru. So he's not in an armored car, not in an armored vehicle. So these are not like the bank servicing their own ATMs, which is, I think, I've seen stuff like that happen, similar armored cars, stuff like that. And that sounds like similar to what you're describing over there in Great Britain. These are not those same types of machines. These are just like private ATM machines and what sounded like maybe coin changers, because he talked about getting coins, that being an issue. But you don't, I've never found an ATM where you get coins out of an ATM. You get things in like denominations of 20. So no, I don't think there was any evidence that would suggest that he was transporting the money with that type of security. Ashley LeBoy, did CSI retrieve the Snapchat data from Libby's phone? They say that they did, but they didn't get all of the Snapchat images. That image from Abby wasn't in her Snapchat data, and it wasn't on her camera roll. So we don't know where that photo of Abby on the bridge came from. The messages disappear once received, and photos live in the app unless exported to the phone. More evidence. Yeah, so they did talk about this. It should be on the phone, but it's not. And they don't have an explanation for that. They don't have an explanation for that. Because it's in Snapchat, you would think that you could get some information about that from Snapchat records. Like instead of going through the phone, go to Snapchat. And I don't know if they did that, because that would show, I would expect, if there was something like, a later login and something were deleted, or a login from a connected device, or a login from a different device, an action is taken on the Snapchat account. I would think that they would have that records, but it's possibly after all these years, they don't. I don't know how long they maintain them. Some guy with cancer. I read from the Indiana Supreme Court today. Prosecutor dropped discovery on defense day before trial. Goal made them go to trial anyway. It happens more often than you would think. I've had it happen to me. You get new discovery, new witness pops up. It's never been disclosed. It's like the day of, and their remedy is, well, you can read it over the break. You can talk to that person over the break. Like there's no accounting for the fact that I may need to follow up on what that person says. I may need to investigate it. I may need to talk to other people. There's no accounting for that. They're very, very accommodating when it comes to prosecutors wanting continuances because they're on vacation, or they just got a lot of cases, or one of the police officers is going to be in a training. Hear that one all the time. One of the witnesses is going to be in a training. When it comes to the defense wanting a continuance because you need more time to work the case, oh, you got to fight. You got to fight. And then, you can't tell them. You can't tell them what you're doing. That's my work product. That's confidential. It's none of your business anyway. You should respect me as an officer of the court with a duty to be forthcoming and direct and sincere about my situation. And so if I am telling you I haven't had enough time to prepare, you shouldn't be looking at me like I'm a criminal. But it does. It happens all the time. Brandon McRoby, he is wrong. I routinely prescribe Haldol in the hospital, doses for severe psychosis, 2 to 5 milligrams, intramuscular 2 to 3 times daily, max dose 30 milligrams. Decanote. Long-acting typically has a maximum dose of 100 milligrams per month. Defensive equals inept. Oh, yeah, well, none of that came out in cross. I have heard that one of the people that has made it onto the jury, somebody has had better notes of the jury and like more time to go back and look through all of them than I did. But I've heard from a couple different sources now that somebody on the jury is a psychologist or a therapist, something like that. And so I don't know. Obviously, that's not a psychiatrist. But depending on your context, there may be overlap in terms of your clientele. You may be working with people that work with psychiatrists. I just wonder if that's something that this person may have had the chance to be exposed to, Haldol being administered and kind of what's normal and what it's like and all that. But that is very interesting to hear. He didn't even have the max doses correct. Yeah, very defensive. And he did come across as, not even necessarily inept, but just he's phoning it in. He doesn't care. He's there to check the box. He's moonlighting his job. He's just trying to work as many jobs as he can. This is the same kind of issue that has plagued a lot of public defense agencies, a lot of counties that contract with public defenders. We had a big lawsuit in Grant County, Washington, a couple decades ago now. The ACLU came in and sued the county because they were basically awarding their defense contracts to one person who was carrying hundreds and hundreds and hundreds of cases, and then was not meeting with people, not investigating, not hiring experts, not doing really any of the things that need to be done to actually do the work of being a lawyer. Because it's in kind of the county's interest to just pay somebody to shuffle things through. Don't cause a stir. Make it easy for everybody. No difficulty. Smooth the path. And that went on for a long, long time. And it's not the only place that's happened. It's not even, that lawsuit didn't even end it. There was another Supreme Court case just maybe now about 10 years ago, State versus ANJ. If you want to look that one up, it's out of Grant County, Washington. It's a Washington Supreme Court case. It's initials because it's a juvenile case. State versus ANJ, and the lawyer, never met with the kid, never really talked to the kid, tells the kid to plead guilty, doesn't do any kind of investigation. And there are, there's problems with that. That's not what your job is. Your job is not to escort people through the guilty plea process. Your job is to look out for their best interests. And same thing like with a doctor. Your job is not to just check the box and file the report and give the shot and move on. Your job is to care for your patient's well-being and tend to it. So he struck me as just the psychiatric equivalent of these public defenders who would take on contracts for hundreds and hundreds and hundreds of cases that they didn't work, because that's how you'd make a lot of money that way. That's what I got. Kelly Jane, wonder if circled initials on MAR have corresponding and in-date order written notes on back of MAR. It's easy to circle after the fact. Call me cynical. Yeah, I agree. A paper record, especially, anybody could have gone in after the fact and circled things. I think that's a very good point. Brandon McRoby, first generation antihistamines like Benadryl are used to treat EPS tardive dyskinesia caused by first generation antipsychotics. Note EPS movement disorders are not totally reversible. That is good to know, that there is some treatment, but yeah, can't be totally reversible. Tardive dyskinesia is, potentially life-changing, potentially life-altering. It's very unfortunate, but I didn't know that. That's very interesting. I guess it speaks to just the mechanism of what's causing it. Almost like it's, I don't know, sounds like it's almost an inflammatory histamine. It's like an immune type of response. Very interesting. Carrie Dodson, one issue I've had is that no one actually saw Richard Allen on the trail or bridge. Yeah, nobody did. Nobody has identified him. Nobody has described anybody that looks like him. Heard a good description of camera guy Heath and some wildly diverse descriptions of someone, but none of Richard Allen. Is that correct? You are absolutely correct. Absolutely correct. None of the descriptions of bridge guy match Richard Allen, and nobody that anybody describes seeing looks like Richard Allen. Felicia, I have posted this before, but this time louder for those in the back. People are sent to prison as punishment, not for punishment. Sociology professor circa 1985. I will just add to this observation that when it comes to being charged with a crime and arrested and detained pre-trial, the process is the punishment. Oh, he can get his acquittal. He can get his acquittal, and it's not going to undo anything that he's gone through. This is life-changing for him, for his family, for anyone that cares about them, for the people that he worked with, everybody. This is never not going to matter as an extremely significant event in his life. A negative, extremely negative, he may never recover from. Kathy may never recover from. Their children, their child. His parents may never recover from. Rick's mother was distraught after court today. It's heartbreaking. Having to know that her son went through that. And for what? Because they lied about his statement and tried to say a magic bullet put him there. Some junk science. Brooke E., are you planning on attending the Kohberger trial? I absolutely am. Yes, I am. How are you planning on covering that case? What role do you hope to play in that coverage? I love your attention to detail, and I'm hoping you'll be covering it. I am. I'm expecting that trial is going to be live streamed, but I'm still planning to go and attend in person. This is Boise is it's not as close to home for me as Moscow. It's like 5 hours away. Moscow is like 2 hours away. But I have family in Boise, so it's very easy for me to go there and hunker down for an extended period of time if the trial takes that long. Honestly, at this point, the way that has been going, it's not clear that there is necessarily a lot of evidence that the state is going to have to rely on. But we'll see. So yes, I am planning. I expect my coverage will probably be a little bit different because there won't be this need for this detailed fact reporting. People are going to be able to watch it for themselves during the day. So I think because of that, I'll be able to shift back a little bit more to my normal way of covering cases and analyzing them, where I'm not the fact reporter. I'm just telling you what I see, like the significance of things that stood out to me, strategies that I noticed, rulings that seemed weird, stuff like that. Just that you get from the perspective of having been a lawyer taking cases to trial. Insight into the process, if there's, legal issues and objections and things like that. That's really my hope is to be able to get more back to that kind of thing. So I would expect to be taking more of like a 10,000 foot view of the facts, or just where details are significant to me, where they stand out, to take note of those and kind of bring those out and talk about them being significant and why I think they're significant and what that could mean for the case. So it's very different. It's very different when there's an independent source of information, reliable independent source of information, because you can watch it happening with your own eyes. This case should have been that. It should have been, but it's not. So we got a little different format from me. I'm really glad to hear that so many people have enjoyed it and appreciated it, because it is not the way I have talked about cases before. I'm not a fact reporter. That's not normally what I do. I'm there to look at the legal documents. I'm there to watch what's happening that everybody can see and talk about what it means. So it's been very encouraging, and everybody's support. I've really appreciated that a lot. Nordic Phoenix, I'm so moved by your moral compass. Following a traumatic brain injury, my son was later diagnosed with schizoaffective disorder due to TBI. I'm an advocate for new mental illness legislations, regulations. Would you team up with me on this? Absolutely. Reach out to me. You can find me. You have to send a message request because I don't keep my DMs open because there's lots of crazies out there. But send me a DM request on Instagram or on my Substack. And I will get that. I'd be happy to talk to you about your ideas and the things that you have in mind. The mental health system in this country is broken. It's really, really broken. People who are mentally ill are at severe risk of crime, severe risk of exploitation, homelessness, all kinds of just negative consequences. I actually just had a conversation with lawyer Lee this morning. It was a little bit of a different context, but it applies to the people with mental illness as well. And we were just talking about how this kind of philosophical concern I've had for decades now, is this idea that once we adopted this, safety net state, specifically in that context, I was talking about Medicare and Social Security. It really culturally shifted what I consider to be kind of an important part of a people's moral development, which is the care of our elderly. Caring for our elderly. These systems have enabled us to just offload that to the government. And so we're not personally involved in that anymore. And that's a part of just the human life cycle and the transition of the generations that culturally we've really lost touch with. And I do tend to feel that's got moral significance to it, the effect that has on us. And it's very similar with the mentally ill. It's just very easy for mentally ill people to be abandoned. I realize it's very, very difficult and demanding on families in both situations. Caring for elderly people who are unwell, it's very demanding. It's not easy. And caring for people who are mentally ill, yes, I do. I've seen and heard so many stories and difficulties and challenges. I understand. And people definitely need support and they need help. But just the systems that we have in place, they're really not working. They're really not working, and people are suffering because of that. So reform in this area is absolutely something that I am interested in, and I would be more than happy to talk to you about your thoughts there. Brandon McRoby, severe neurotoxicity manifesting as rigidity or inability to walk or talk may occur in patients with thyrotoxicosis, also receiving antipsychotics. Also explains the proptosis of his eyes described. That is fascinating. We never got any explanation for the eyes bulging out of his head. It was just there for like a long time, and then apparently it resolved. Yeah, after he was no longer on the antipsychotics. That's very interesting. That's very interesting. I don't know what thyrotoxicosis is, but I'm going to write it down so I can look it up later. Sounds like it involves thyroid. Just my guess. Some type of hormonal maybe reaction. I'll look it up. You don't have to tell me. Very interesting insight. Jessa, thank you so much for your excellent coverage of this case. Also, if you haven't read America Prison by Shane Bauer, I would highly recommend. I'll write that one down. It's now my second recommendation for a good nonfiction book about prison conditions. Yeah, I would like to take a look at that. Artsy Fartsy Designs by Shar. I got my possible jury notice today for Carroll County. Yes, you are in the position to be a hero. I hope if I do have to, I don't have to witness anything like this. I hope so too. I got to think the odds are low. Just not that many cases like this, right? Most of the things, the reality is you get your jury summons. The case that you're summoned for, it's probably not going to go forward. I mean, most of the time they don't. They have to summon jurors way ahead of time, and things can change in the interim. So getting the summons is definitely no guarantee that you'll even need to show up to serve, because things can change. But if you do, most likely things that I see going to trial in circuit court, meaning felony types of cases. Domestic violence is very common, and that's, in part because there's a lot of denial involved in domestic violence. So very difficult for people to accept responsibility and plead guilty and take consequences. Sex cases, if this is a felony, fairly common for those to go to trial for very similar reasons. Less common to see things like, sometimes you'll see drug deals. Somebody's been busted by confidential informants, and maybe there's issues with the informant, stuff like that. Fairly common to see. Those are the most common types of felonies that I can think of off the top of my head that I expect to see go forward to trial. If it's not in circuit court, it's a lower level. Then it's often going to be like DUI, driving type of offense. Still see DV, but like on a lower level. Not as serious, not as not using the right words. All domestic violence, of course, is serious, but just meaning not as injurious. Let's put it that way. So no, you're probably not going to get a murder case like this with this type of corruption and all of that. But boy, after what I've seen of this police department here, this sheriff's agency, shouldn't say that about the police department, because I haven't seen the police department at all. I don't know how they are, but the sheriffs and these ISP, boy, I'd be having some serious questions if they were witnesses in a case. Truth and trauma. Thank you, Andrea, for your inspiring passion. Also to the line sitters who ensure the world hears her, Lee, and Bob. Yes, thank you so much to the line sitters. I am so grateful to them. And it's what I'm really particularly honored by is the fact that so many of them, they're local people. They're local people that have stepped up and are doing this so that I can give you these reports. And it's just that it really means a lot to me. Because I've said before, I recognize I'm not from this community. I'm an outsider in many ways. And nobody had to step up and do that. And there's been an army, and it's been overwhelming and so gratifying. And I will tell you that Hoosiers are now some of my favorite people because you guys are awesome. It's just very been cool. Auto Doctor 911, didn't he also get asked about feigning? It was only the question at the end from the jury about whether his presentation on the June 20th video was consistent with feigning, and he said no. So that was the only question that he had. They didn't ask specifically about, they asked, like, you give Haldol for psychosis, right? They didn't follow that up with, you don't give it for feigning. That might have been a helpful question to ask. But the bottom line was no, they didn't really get into it with Dr. Martin. My dog is my ears for Andrea's pen fetish. Does Jeff know? Oh, once he sees my blue Sharpie S gel, he might be swiping these. The Sharpie S gel was his pen. These are very nice pens. It's 0.7, so it's a little bit bold. Such a good pen. If Richard Allen is acquitted, never be able to live a safe, normal life without the constant title of CK. LE has labeled him, but LE must be investigated. Justice for Libby and Abby. Yeah, there's always going to be people that no matter what the jury does, they will have decided. And it's like that with anybody who's acquitted. And that's part of how the process is the punishment. It's life changing. Johnny Depp on the stand talked about, as soon as the accusation was made, it's over. You never go back from that. Even after you go through a trial and you prove convincingly to a jury unanimously that she's lying and she slandered you, there's still going to be people out there that are just going to insist that, it's your fault. You did it. It's really victim shaming. It's really victim shaming. So yeah, he will never go back from this. It's never going to be the same for him. And I agree that if this law enforcement agency is not being investigated by the FBI, I've said this before, I don't know why we have an FBI. These conditions in this prison and these officers and what they did to set up this case and the dishonesty that they've shown. Yeah. If they're not being investigated, then I don't even know why we have an FBI that's supposed to be in charge of investigating corruption in public agencies. Brianna Lusick, did you see how the jury reacted to Dr. Martin's testimony? Also, what is your pin today? I really didn't see, because he was also very quiet. He did have his accent, and he spoke very rapidly because he was so nervous and trying to get so much out. So I was really focused on him to try to capture as much as I could from his testimony. Didn't really get an eye on the jurors to see what, if any, reaction they were having to it. My pen today just showed this beautiful blue Sharpie S gel that Lisa Shelton gave me as a gift. I love it. There's another one there in my bag. I like this one better than the one I got as the mystery gift the other day because this one is blue. I do like my blue ink. I saw, by the way, there were some jokes flying through the chat about being a spy pin, and I will tell you, I shit you not, I took the pin apart to check and make sure there was nothing in it. So, I mean, I suppose there could have always been something like stuck in on the wall of the pen or whatever, but no, I took it apart. It looks like an ordinary pen. So you guys weren't alone. You guys weren't alone in thinking that. I really did. You just don't know. You just don't know. What a weird time to be alive and be here. Susie with a $4.99 super chat. Thank you so much for that. JD, I think we're all feeling your frustration and exhaustion, Andrea, but we're so grateful for you. I wish they could show the interrogation video again to show who Richard Allen was before this nightmare began. Well, they will have the option to display the exhibits in their closing. And so if they want to play parts of it, they can. They can. So maybe they will. And that might be that might be a smart thing to do because your eyes are very persuasive. Talk is cheap. I tell juries all the time in my closing arguments, talk is cheap. So if they can see it with their own eyes, this is who he was before he went to Westville. Here's who he was after he was subjected to what they put him through. It's pretty dramatic. It's pretty dramatic. Sindish with a $10 super chat. Thank you so much for that. Appreciate your support. Skeptic Curiosity. If a verdict isn't reached by Saturday, will the jury deliberate on Saturday since they've been having court on Saturday until 1? Thanks, Andrea. I kind of expect they will. I would expect they may just deliberate until they're done. Meaning like maybe Sunday also. I just don't know. Sometimes the court will leave it up to the jurors to decide what they want to do with stuff like that. Sometimes they won't because they do have to have, the court staffed and be prepared to open it and come into session and so forth. So they may be prepared. I mean, they've already, at least in theory, because the trial was supposed to go until November 15th or 9 days ahead. So they're at least in theory already prepared to staff the courthouse for this Saturday. So yeah, they might. I don't know about Sunday. If they're going that long, I don't know how I feel about that. I don't know how I feel about that. Tomorrow's what? Tomorrow's Wednesday. Not very good at keeping track right now. I did get more sleep last night. I got about 6 hours last night, but I still have my sleep debt. I had about 3.5, 4 hours the night before. So I came home from court today and took a nap, and I was pretty out until I had my alarm set to wake me up to come do the live stream. So I'm not very good at keeping track of the days at the moment. But yeah, I mean, if they have Wednesday and they have Thursday and they have Friday, it is a big case and there's a lot to go through. But I also just think about how they have this special process in Indiana. They've been able to talk. They've been able to essentially pre-deliberate about the evidence. And it's hard for me to imagine that they wouldn't be doing that, especially when they're being sequestered. They're all together all day and all night. So it just seems like they would have had like a running start at kind of figuring out, what they all think of all of it. Claude Simeon, high school civics 30 years ago said defense has the last word because presumed innocent. Was that wrong back then, or prosecutor rebuttal case new? Any jurisdiction without? As far as I know, the common law has always been the prosecution goes last because the prosecution has the burden of proof. So I'm not aware of this being a new rule. This is a common law rule. Pretty much as far back as I've seen. I'm not familiar with any jurisdiction that doesn't do a prosecutor's rebuttal. Same reason the conventional courtroom architecture is that the prosecution sits closest to the jury. The defendant sits further away. That's not the case in this particular courtroom. It is reversed, which I noticed, right off the bat. I don't know if that's really significant. I don't know if there's been studies on that or anything. I would be kind of interested in looking into that, following up on that. Do you get different outcomes if you move people around in the courtroom? It's a very interesting idea. But yeah, as far as the rebuttal goes, it's because the prosecution has the burden of proof, so they get the last word. Hedgie Mom, Elvis Fields' sister took a polygraph testifying to what he had told her, and she passed. Yes, she did. That did indeed happen. But that's apparently not a direct link. Mimi's Garden, question. Andrea, did you get the details I provided about time for, yes, I did, for Brad Weber to get to car in Subaru lot? Time is logged at turnstiles in lot, not inside the plant. Yes, I did. I got this message, and thank you so much for sending it. So what I remember from this message is that you were saying that the turnstiles are basically when you were already at the parking lot. So it would not take very much time to get to your car from the turnstile, and that there's not going to be any other, there's not another gate or anything like that you have to go through on the way out. And so that would seem to minimize the time that it would take for him to get through the turnstile to his car, and then from his car, out to the driveway or out to the roadway where, is where I would expect the Google time estimate takes place. And so this is a question that we'd had because that was testimony that I believe it was Steve Mullen gave, that he went and, checked it out on Google Maps, what the time, the distance to do the drive was. And so Google Maps, is not going to take it back into the parking lot. It's going to start, they typically start on the street in front of the building, at the address. And he said 20 to 25 minutes, depending on traffic. So that was a question that was out there about, but how long would it take for him to actually get out of the plant and onto the road? And so from this information, it doesn't sound like it would take that much time, maybe another 5 minutes at most, maybe just a couple. I guess it just depends. I can see how it would depend on how many other people are leaving at the same time. If he's leaving at an unusual time because he got off early from his shift, then you would expect, it's not going to be a situation where a lot of people leaving at the same time, and you might have bottlenecks and, have to wait a little bit to get out. Like when you're trying to get out from the concert or whatever, and, a billion people are all trying to get through one exit. So it doesn't sound like it would add a significant length of time to his estimate. So just another piece of information there. According to their time frame, he could be there as early as 2:22 in the afternoon or as late as about 2:27 in the afternoon. And then the time between that and 2:32 is really the focus. That's when they would say, that's when Richard Allen got scared and got the girls across the river and did what he did and then killed them. So is that enough time to do it? Depends on what all it is. When you have the redressing and stuff like that, the gathering the clothes, the dumping the clothes. Don't know how long it would take to get across that creek. Just depending on the conditions. I mean, I don't think it would take that long, even if it's like high and there's a strong current. But, just it would take longer if it is high and there's a strong current, as opposed to if it's very low and you're essentially just like, wading across, stone skipping kind of across. It does. I mean, it fits the timeline. I think that's why they wanted to bring that up. So, my dog is my ears. Would other defense attorneys want to somehow get involved in a pro bono way after the treatment the Richard Allen's D's received by judge and state bias and what's possible? This something ignore or if convicted. If I'm understanding this correctly, as far as getting involved in a pro bono way after the fact, I would think so. People do pro bono work. People do a lot of pro bono work. So things like the prison conditions and stuff like that. And honestly, a lot of what's needed is it isn't even legal work. It's not legal work necessarily that people need. They need eyes on this stuff. They need monitoring. Like, I don't know what the visit policy is in the MCU. I don't know if they get no visits. Where I'm at in Washington in what they call the Administrative Segregation Unit, ADSEG. That's our equivalent to solitary confinement, but it's really not, because there is still, out time, and they still will get visits and things like that. It's not great. Not a nice setting at all. But it's not like what Mr. Allen had to go through. And so things like that, if there's ways to arrange visits, that can be a little bit difficult because you have to coordinate with the people that are inside. They have to have you on their visitor list. You have to be approved on their visitor list. You can't just show up and volunteer to visit people at prison. But I would like to see something like that, be organized, just so that to the extent that it's possible, people have some human contact and people have eyes and somebody checking in. I can't tell you how much sometimes the most important thing that I did as an attorney was just show up and care. That's it. There's nothing I can do for you about your case. There's nothing I can do for you about this evidence. It's really damning. It was legally obtained. You're going to get convicted, and the sentencing is what it is, and your history is what it is. But all I just by showing up and caring and checking in, it just that has a huge impact on people, because these, people that are in jail, people that are in prison, people that have been accused and convicted of crimes, these are throwaway people. That's what the prison system is for. You hear it, people say that outright. Throw them away, lock them up, throw away the key. They're throwaway people. And so one of the most important and impactful things that we can do is to simply refuse to throw them away. Everybody matters, everybody counts, and act accordingly. So, yeah, I definitely am open to pro bono, and I'm sure other lawyers are open to pro bono. But honestly, with stuff like this, I don't know that that's really where the big need is. I really don't, because If you got a good civil suit against the Department of Corrections, you're going to find lawyers who are willing to take that on because it's potentially lucrative. But just that basic human contact and human connection, and reminding people, yes, you have basic dignity as a human being. You are a redeemable person. It's very easy to forget that in these kinds of contexts. So that's the kind of thing I'd really get behind and love to see some kind of way to make that happen. Jerry Gray, do you know why Judge Benjamin Diener recused himself, and is it possible Gull is one of them? So we went over this last night. We looked at his recusal order, and it really doesn't specify. It just says for reasons, circumstances unique to this case, he's recusing himself and the other judges that would normally, locally be appointed to take it over. So asked the Supreme Court to appoint a special judge, and Judge Gull got the nod. Is it possible? I mean, I don't know. She's not from here. It seems weird to me to think she'd have connections with, many of these people, but I don't know. I mean, the ISP is going to be statewide. They'll have like regional areas. People are usually assigned to a region. And so I don't know if there's like a lot of crossover between, we heard a lot about Lafayette, the Lafayette Post, and Fort Wayne. I don't know. I don't know. I don't know what the judge's issue is. I mean, I don't necessarily get the sense that it's personal. This seems to be like, it seems to me, honestly, like it's just much more directed at the defense lawyers, particularly Mr. Baldwin. It really seems to me to be focused on Mr. Baldwin. And just this antipathy and this antagonism that, when we're not in the presence of the jury, she's just dripping with contempt, sneering, dismissive. These orders that she wrote, the kicking him off the case, he's a victim of a crime. And, victim blamed him. You were negligent, grossly negligent, careless, reckless. I don't even remember what all the language that she used. Unprofessional, she's called them. These guys have been nothing but professional throughout the course of this trial. I can say that. What I've seen with my own eyes, these guys have been far more professional than I think a lot of lawyers would have been under these types of conditions. A lot of people would have snapped back at this judge. I don't know what her issue is. Holly Clay, did they say who was on the trail cam on 213? So they said, here's what the testimony was, that there was a person on the camera on February 14th that they identified as something that nobody could hear consistently. Like several of us put our notes together. We all heard different things, but multiple people heard the word fireman. And that possibly another person was on the video on February the 13th. That's all we heard about the trail cam. So we got the one person on the 14th, possibly identified as fireman. And on the 13th, maybe a person, maybe not. We did not get to see the trail cam. So I don't know how significant it is, other than the fact that the state didn't bring it up in their opening, in their case in chief. Jason McClellan, how would you rate the state's performance and strength of their case out of 10? Ditto defense. I'm going to rate the strength of the state's case as about a 3. I'm going to rate their performance as about a 4. They certainly had high points, but they had a lot of low points. And they really, the big shooting themselves in the foot was making themselves look deceptive. It's really an own goal. Just a lot of things that I saw that I thought were really bad judgment calls. Being sneering with the objections on, I don't think this is relevant. Well, it's, could very well seem to other people, including the jury, to be relevant. So it's just not a good call. to be trying to use tone to communicate substance. If you've got substance, you don't need to be doing stuff like that. Same thing with like Mr. Luttrell's cross-examination of Dr. Eric Warren. It was just so over the top, rude, unnecessary, argumentative. It makes people uncomfortable because you're being so disrespectful, and there's no cause for that. You're not bringing the goods that would justify that kind of treatment. And I didn't get that same type of vibe from the defense, even when they were being tough on the state's witnesses. When they're being tough on the state's witnesses, they're being assertive and they're being direct and they're saying it how it is. But they're not really saying it like contemptuously. There's like really just only a couple times I can think of, like the one earlier today where Dr. Martin is talking about all the people that were concerned about making Rick Allen's conditions more comfortable, and he says, he names Gallipo, and Rosie's like, "You're saying Gallipo was trying to make his conditions more comfortable?" That was a bit of a swipe. That was a bit snarky, but that's really been the exception for the defense. They haven't been like that. They've just they've come with the goods. Auger the other day with you did a Google search. I mean, she's being very contemptuous of that. You had 7.5 years and you did a Google search. But the thing is that when you're very selective with it and targeted with it, it's much more effective than when it's kind of just this broad brush of like everything the defense does is irrelevant and stupid. I mean, that's not, I don't think the jury is going to see it that way. When it comes to substance, like I've said before, Mr. McLeland, he's got a lot of skills as an attorney. He's very good at being concise, at using the open statements to get the witnesses to where he wants them to be. He conveys most of the time a lot of confidence in his demeanor and in his presentation. That does then contrast with when he doesn't project that. You notice it. You're like, oh, are you nervous? Are you scared? Like it stands out. But he did do a very good job, and he landed some blows. He got out some very damaging information. So from my perspective, Nick McLeland is very much the star of the prosecution team, and the reason why they got pretty much every advantage that they have. The deputies were just we're just mid to potentially in some ways detrimental sometimes, because they didn't really know what they were doing and how to do it. And we saw that with both Ms. Luttrell or Mr. Luttrell and Ms. Diener, that they would try to substitute like tone and smarminess for having actual substance, especially when they're cross-examining these experts. And it just doesn't work. It's not effective, especially when they then turn around and show that your question is stupid and they cut you off. And so your attitude is really uncalled for. So that's the basis for my rating for the state's case. The defense's case, I mean, the defense doesn't really have a case, right? The defense is there poking the hole in the state's case. As far as their own case and what they presented, I mean, I got to put it about the same. I got to put it at about a 3, maybe a 4. They certainly didn't solve the crime, but that's not their fault. Their hands were tied behind their back. It's almost like I feel like I need to weight it for the defense because of they were, this is just what they had to work with. It's not necessarily what they wanted to do. The prosecution seemed to have pretty much free reign. The defense absolutely did not. The defense was constrained, every which way they turned. But they're really key pieces of information they brought out. The headphone thing, very important. The videos, Very important. Just the overall conditions of confinement and the significance of that with the experts and so forth. Very, very important. I'd say that's got to push me up to like more of a four or a five. Betsy Blair with the timeline with the car. I mean, that was less important just because the state ultimately never ended up really trying to put Rick's car in the CPS lot. They just did that, in the probable cause affidavit, but they didn't have anybody that would be able to do that at trial because they're relying on Betsy Blair, who described something completely different. And then otherwise, the bulk of what they were exposing was just the kind of ineptitude / intentionality, with the bad investigation. They really, really pantsed Mr. Mullen, pantsed him hard. And he looks terrible after this trial. He looks absolutely terrible. And, the van is still not a great thing, but they were very, very successful at making it seem very credible that, he set that up. His own story, his own story did that, but they were then able to use that to show the jury. Look at how this doesn't add up. This guy is supposedly not, Brad Weber doesn't even know what the topic of the conversation is. And yet he knows to come into that interview and volunteer without even being asked what his timeline was and has checked his cell phone, his text records and stuff. That's a remarkable coincidence. How do you explain that? I have no explanation for it. Yeah, we know you don't, but we do. We do. So the strength of their case, I would lean on about like a 4 to a 5, because you want more, you'd love more, but it's what they got. As far as their performance, I give them like a 7 to an 8. I give them like a 7 to an 8. Again, you got to account for they got their hands tied behind their backs. But they scored the points they needed to score when they were allowed to. They didn't have that many missteps. I mean, I called out the missteps when I saw them. The one that still stands out to me is the one from Ms. Auger. When she had, I'm pretty sure it was when she had Cecil on the stand for Sergeant Cecil. And she's like, you searched all of his, all of the electronic devices that you seized from his house, and none of them had any, showed any connection with the crime or anything like that. And then the state's able to come back and say, yeah, that you didn't have that 2017 phone, did you? And then we know that there's photos of like devices after devices after devices. And apparently the 2017 phone was not seized. Can we rely on that? Do we trust their record? I don't know. I'm gonna see if the defense addresses that in their closing. What, if anything, they do with that? Because that is the thing. I called it out at the time. Like, that doesn't sound good at all. He's got all these phones and the only one he doesn't have is the 2017. That doesn't sound good. But they never really like super defuse that. I mean, they got some cross-examination from Rosie with one of the other witnesses about how you have no idea, what his practices were, what he stored, what he didn't, what he kept, what he didn't. You don't know if his habits changed. And these are all true, but it's just the questions are not themselves substantive evidence. So that was a misstep. There were a couple times when the defense asked too many questions. Did that ask too many questions? You don't have to try to get the jury to agree with your conclusion. That's what you have an argument for, or the witness, especially a hostile witness. You just get the facts from them, and then you argue what the facts mean to the jury. You don't ask the witness to confirm what the facts mean, because they will not do that if they're hostile, and you're just giving them an opportunity to give their own explanation. And then it's just defused what you've just accomplished. So they did have a few of those missteps. It certainly was not a perfect performance. The opening statement, it wasn't ideal in many ways. It was a little bit disjointed and kind of hard to follow. Because I know there is a lot to the case, and they didn't have a whole lot of time to cover the basics. But he does have, I've said it before, that just special quality of just being authentic and being able to connect. And he made those critical points about just please wait for the defense case, hold the state to their theory because they're going to have to change it. And I think he's right. I think we saw that. So that's where I'm going to leave it. Lower performance and lower just overall quality of the case from the state, higher performance by the defense, and slightly higher quality of the case. Annie, if a mistrial, any hope and argument can be made for Richard Allen to get house arrest instead of back to solitary confinement? They can try, but it's a goal. It's going to fall on deaf ears. But they can try. I would expect them to try, but I would expect it to go nowhere. His bail is at something like $25 million, wasn't it? I don't know if they ever modified that, but it was just, it was some completely unrealistic amount of bail that was set. So Megan L., what's the state's deal with Elvis Fields? Why Richard Allen? I don't know that the state's deal with Elvis Fields is particular to Elvis Fields. I think the theory is that it's the collaterals. It's the people that Elvis Fields is associated with. And so Elvis Fields is just kind of a problem because he's saying things he shouldn't say. That's the theory as I understand it. I don't think anybody is saying that Elvis Fields is got an in with law enforcement or something like that. But it just is curious to me, the grace that these third-party suspects got in the early days of the investigation when they were getting cleared for things that, they didn't clear Richard Allen for. When Richard Allen said he was on the trail from 12 to 1, they didn't just take his word for it. But when some of these early suspects were like, oh yeah, I was at the hospital that day at this time. All right. That's good enough. No follow-up. No indication that it was ever followed up on. They just said, okay, we'll clear him. They wanted Richard Allen's phone to be able to go in it. They asked him to give it over voluntarily. And he was initially willing before he realized, oh, you also want to search my house and my car. You guys seem to be focused on me, so maybe I'm not going to do that. I don't think they even asked Brad Holder. So it's just a little peculiar how all that played out. Oh, Susanna, shine the light on it, Andrea. Speak it, sister. Thank you so much for all your work and efforts. Well, thank you. Thank you so much for being here. Thank you for sharing your voice as well. Auto Doctor 911. Headphone info not great. Shows phone probably got wet 5:45 p.m. though. Messes up the timeline. I mean, that's the thing. If the explanation is supposed to be water or dirt, how did this happen at 5:45 when the final event is supposed to be 2:32? The phone stops moving then and never moves again. So what's the explanation for why a phone is sitting there for 2 hours functioning perfectly fine and then apparently suffers some kind of damage 2 hours later while it's been sitting under Abby's body? I don't think that's I don't think that's helpful information for the state at all. I mean, even if it is water damage, even if the jury is willing to buy that, doesn't help their timeline. You don't have Richard Allen there at that time. The search is going on at that time. The search is going on at this time. Jason McClellan, would you have put Richard Allen on the stand? So I don't know. And I've talked about this before. What I've said is that when I have a defendant that is innocent and is proclaiming their innocence and the facts seem to support their claim of innocence, everything else being equal, I want to put that person on the stand. because I want the jury to be able to hear from them and get to know them. It's natural for the jury to be looking at this person the entire time. They're hearing all this stuff about him, and they just want to know. They just want to get to know him. They want to hear his own story. And there is that little bit of prejudice of if I was innocent, I would shout it from the rooftops, you know? And so even though they get the instruction that you can't hold it against him, I just always feel like, I know that they want it on a human level, and I would like to give it to them. I mean, I just gave the story about, put a convicted sex offender on the stand to testify because we needed him to, and it worked. The problem, though, is because I don't know Richard Allen, and I don't know his current state, and I don't know if it's realistic that he would be able to do it, because the cross-examination that could be quite difficult. And so I just don't know if if he's in the emotional place really to be able to deal with that. So I don't know. Everything else being equal, if he could, yes, I would love to, but I don't know if he could. So Megan L., have you taken another look at the probable cause affidavit? I count 10 lies, 5 inconsistencies between affidavit and testimony in court, and 7 unclear, incomplete statements. Thank you. I was starting to notice a lot of this early on. I haven't gone back and like redline the total probable cause affidavit. I'll make a note of that. That could be another thing. Another thing to follow up on Substack. How did it hold up? I did look specifically at the claims that were made about the bridge guy video. Somebody reported, in the probable cause affidavit, there's an accounting of the bridge guy video. So I went and looked at that and compared that to what I saw. And there's, like 5 things in there that are not borne out. Not borne out by what I saw. So yeah, it wouldn't surprise me at all that there's a whole lot of stuff that did not survive the light of trial. Lawyer Lee said yesterday she didn't think defense did well with jury. Your feeling? Obviously, we all have different experiences, points of view. Stay warm. I don't know that we can really say. I mean, to the extent that I saw body language, it wasn't dramatic, and it wasn't a lot of jurors showing it. It was very few of them. There was the one juror who seems to be very narrow eyeing the prosecution, and doing a lot of long blinks of the prosecution, while then having that whole body open turn body language towards Mr. Baldwin. That suggests to me that that particular juror, at least, is more receptive to the defense than to the prosecution. The juror who, during the time the videos were shown, leaned way down and, stared down, gave that long stare to Mr. McLeland. That didn't look like, the prosecution landing well with the jury. So, it's just hard to say. It's just hard to say. The jurors are reserved, for the most part, and that's appropriate, and they should be. So you really just have to kind of gauge it from their reactions to the evidence to the extent that you can see it. Biggest reaction I saw was those videos. Those videos made a huge impact. They made a huge impact. My view overall has been that the defense has come across as more sincere and more forthcoming than the state has. But I don't know how much of that is just my perception. The jurors come in with their own backgrounds, their own biases. We all have the biases. There's no point in trying to pretend anybody is unbiased. We're all biased. Just because we have life experience that has trained us to see and think in a certain way. So I don't know that we can know. I don't think I would be other than like the specific things that I pointed out that I feel like there's objective reasons to think that there are, reactions to one of the parties here. I don't think I'd be comfortable making kind of a blanket, who landed or who didn't. Kara R. Todd Click, Rushville ex-cop connected to Delphi, leaked evidence, was on defense witness list, is now arrested in Ripley without bond weeks before Richard Allen trial, connected to Holman, was 32 years, state cop 2. Odd. Yeah, the Todd Click thing, that's one of the side stories that I'm kind of interested in following and seeing what ends up happening with that. So he got arrested because he went to work for CPS as an investigator after, I believe he was fired. I don't know, though. I'm not 100% sure on that. But he was one of the original investigators of the Odinism theory. He's the one that wrote the report, the Click report, that he provided to the defense. If that's what you mean by leaked evidence, then yeah, he did do that. I don't think it was like a situation where he leaked things to the public, at least not that I know about. But he did. He provided the Click report to the defense. I don't consider that a leak. That's exculpatory information that the defense should have had. That's Brady material. So that's like the ethical thing that you're supposed to do that the prosecutor should have done a long time ago. But so he went to work for CPS. He was an investigator there, and they arrested him because people claim that he was putting things in his reports that he didn't do. He was basically falsifying investigations. I'm going to really wait and see on this one. I'm going to really, really wait and see. Because it's really unheard of for claims like that to be taken seriously. People make claims like that all the time. The caseworker did this, the caseworker did that. And a lot of times that is because, for all the same reasons we just talked about, drug addiction, abuse, so forth, there is often a lot of denial in these settings. And so I hear that all the time about what the caseworker did or didn't do. And the caseworker, more than likely, most of the time has a different version of events. So it's almost unheard of for those types of complaints to even be taken seriously, let alone escalated to the point where somebody is investigated and arrested. It's very unusual. So I want to keep my eyes on that one. Loopy Lou 81, does White Van Guy have more evidence against him? Well, his gun can't be excluded as contributing to the bullet, and he places himself at the scene of the crime at the time, shortly after the abduction. Think you can make the argument. That that's more than with Richard Allen. Of course, he wasn't tortured into confessing, so they don't have that. Just depends on how much weight, I guess, you give to different pieces of the case. Charlie Lynn is gifted a membership. Thank you so much for that. Lauren, you said the girls didn't have lividity when found. If they were killed approximately 22 hours before, there would be lividity. The state's time of death is wrong. So here's what I saw, because we didn't really see as to Abby. There was a single photograph that was shown in court where the crime scene investigators had lifted Libby's body, like tilted it onto the side so that they could photograph the ground she was lying on underneath. And so you could see the backside of her body. Some of it is blurred because they're, covering parts we shouldn't be looking at. And a lot of the rest of her back was just like covered, like very densely covered, packed with like leafy material. So you don't have a really clear view, especially because like what you can, even though it's blurred, like it's, the buttocks area is kind of what's visible, most visible. But that's also where, that's your pressure point when you're lying down, that's having contact with the ground, and women, that's your center of mass. So most there's going to be a lot of weight on there, and that's not going to be where lividity is going to tend to show up. But we did see in the autopsy photos that, where they were showing lividity, that where it was showing is kind of like, it's on the back. So, definitely areas that would have been covered by the leaves, but also kind of coming up, towards the sides, like over towards the rib cage. And that's where I was looking when this photograph was shown on the camera. I was looking for lividity there because it was like the closest thing that you could see, that wasn't completely covered by leaves. And I didn't see any sign of it there. It's a quick look. It's an imperfect picture. It's up on a screen. That's just what I saw. But the jury is going to see it. They're going to have all those photos. They've had copies of them that they've been able to, look at and flip through, think about. So that definitely stood out to me. If there isn't lividity set, then that should give us at least a way to narrow the time frame of the time of death. Jessica Gilman, Rosie was my attorney years ago and bluntly told me I needed to take accountability in court and get treatment. I can now appreciate his morals. Yeah, that's what you got to do sometimes. That's what you got to do sometimes. You're not helping yourself. You got to just tell people, I want to help you, but this is not something, this is not how I can help you. What you want from me is not help. Here's what's going to be better off for you in the long run. Summertime, when the defense said time to be journalists. Yeah, I remember that. That was Mr. Baldwin said that, wasn't it? ACSW, is there a way for them to allude to not being permitted to give third-party culprit evidence in closing or any other restrictions imposed on them? They cannot refer to it. That would be contempt. I'm sure that they would be reprimanded at the least for doing something like that. So no, they can't hint at any of that. I think really the closest they can get to is, the implication that if Richard Allen didn't do it, by necessity, somebody else did. And because of the way that the investigation was handled, all this information was lost. We got to question whether we have the right guy. I think something like that's very general and just more abstract. That yes, as a matter of logical reasoning, he says he's innocent. He's presumed innocent. If he is in fact innocent, then somebody else did it. But they can't get into, we think we know who, or we could have proven, or we could have presented him, or anything like that. I think that's about as close to the line as they can get. Somebody else must have done it. And because this investigation was tanked from the very beginning, we may never know who it was. That they could probably say. Carazola X, have you gotten a chance to see the Karen Reed Supreme Court arguments yet today, Andrea? No, I have not. I did see that they happened, but I have not had a chance to look at those. Probably won't tomorrow either. It just kind of depends on how long the day goes. But once we get into the verdict watch and I will be catching up on everything, then I may get a chance to look at it. Marcelo saw for the first time a Supreme Court hearing for the Karen Reed case today and thought, Andrea is such a badass for being able to do this. The way the judges asked questions mid-argument, get some good sleep. I'll tell you what, for me and most of the appellate attorneys that I know, the judges asking the questions is the best part. Like my deepest fear is going into an argument and the bench is completely cold and they have nothing to say to me. And then I've got to carry the thing the entire time. The questions open up a conversation and it allows you to speak to the judges on their own level. It reveals to you what some of their concerns are. When you walk into a court for oral argument, you're blind. You have no idea why they want to hear from you about this case, what they want you to focus on, what they're thinking about it. You walk in completely blind. And so you only get to learn that through the questions that they ask. So for me, that has always been I feel like I thrive most in that part of the argument when it turns into more of a conversation and a discussion with the court, even if it is challenging, even if they're pushing on me, because that's my job as the attorney, is to have anticipated these are the weaknesses. And here's my answer to that. So It is a very different practice than trial practice, arguing in appellate courts. Different styles of badass, all around. Some guy with cancer. Goals keep safe order is even worse. She told the prison to not bring a subpoenaed witness for the defense. Yeah, I remember that. They had subpoenaed that guy that wrote the letter. I can't remember his name now off the top of my head, but he'd written a letter complaining about the conditions and about how Mr. Allen was being treated, and they had gotten an order for him to be brought over, and apparently their claim is that he decided he didn't want to, so they just said okay. You think you or I could just say, okay, I don't want to follow a court order. I don't feel like going there today, even though they've compelled me. And they'd just be like, okay. Yeah, it's a very good point. I had kind of forgotten about that piece of it, but that is definitely there. Allison Parks, there are just no words to say how thankful I am for you. My husband and I have watched every one of your videos. I just kept looking at my husband thinking, you could be Rick. Breaks my whole heart. Well, thank you for that. This is a very heartbreaking story on every level. I'm heartbroken for Rick, and I'm also heartbroken for Abby and Libby and for the families. I really am. It's increasingly hard to find justice and hope in this story. It's very bleak. It's very bleak. And that's why I think so many of us are putting so much hope in the verdict, because it's the only chance that we have for some kind of sliver of justice out of all of this, that we shouldn't even be asked, like it should never have gotten to this point. It shouldn't even be an issue about whether Rick Allen is acquitted. He never should have been charged. After seeing this case, he never should have been charged. But that's really the only hope we have for something positive to take out of all this. And that's really unfortunate. It really is. It's not getting us any closer to justice for Abby and Libby, that's for sure. And that's a real shame. And that falls on the prosecutor and the investigators. Donna Brack, Andrea, I don't understand why Keegan Kline did not take the stand. It was televised that he was going to. I believe that he should have, as he did text one of the girls under fake photo name. Thoughts? Yeah, he's third-party culprit. He's excluded under the order. There was never any way they were going to be able to bring him in once that was excluded. It's a suggestion of a different perpetrator. So that's the reason why they weren't allowed to. It's the same thing with the other DOC witnesses. As far as I know, they weren't allowed to. So that's why they didn't. Brenda Schmidt, is there any significance to the wounds being vertical? Thank you for your reports. I've been following this case from the beginning. I wondered about that, if there was like medical significance for this. If there was, we were never told. I have no idea if there is, symbolic significance to it. As far as the Odinism thing goes, it was significant to me just because that's very unusual. It's not what I would normally expect to see if you're dealing with a case where you're hearing about somebody's throat being cut. Normally it is across, it's horizontal. So this vertical tells us a couple things. Sorry to be graphic, and I hate to have to say this and point this out, but it means her head was probably held back, so that they had the access to be able to make the cut. Other than that, I don't know. Other than that, I don't know. Jim Green, keep up the excellent work, Andrea. After hearing all the forensic evidence, do you have a view on the plausible alternatives as to who and how this tragedy, the murders, occurred? I really don't. There's just not enough. There's not enough. I'm intrigued by the third-party culprit, and I wish they had been able to bring that out in trial, because I think that would have gotten us a lot closer to being able to flesh out what are the alternatives. This seems like a plausible alternative to me. You have confessions, you have this very, strange, suspicious looking behavior. You have these links between the people. You have this bizarre crime scene that hasn't been explained by any other person in a credible way. Like, no, this is not concealment. That's not credible. That's not a viable explanation. The Odinism explains it. Seems wild, seems very hard to believe, but it explains the weird crime scene. So I really wish they had been able to bring that out at trial and flesh that out, because I think it would have helped us vet it and know, is this just kind of some crazy reach thing, or is there something to this? Because it really does seem like this crime scene, if it's not Odinists, then it's somebody who wanted to make it look like Odinists. I mean, it just looks just like that picture Brad Holder had on his Facebook. The girls on the ground looking dead with sticks on them. Threads and Roses, what are your thoughts about the Odinism evidence? I mean, that's it. I wish we had been able to flesh it out at trial. I really do. Because it's hard to know without having that crucible. You know, the cross-examination, the testing, how do they hold up under the scrutiny? How do they handle up under confrontation? How do they handle conflicts, contradictions? Really should have been fleshed out at trial. And then we'd be in a much better position, I think, to have an opinion about it. Lindy, I'm concerned the jury is still asking questions about feigning at this point, the end of trial. Thoughts? I'm not really. I mean, it is an issue, and it's something that they have to evaluate. They have to consider. I think it is a legitimate question. Now, I didn't read this particular last question directed towards Dr. Martin as necessarily being like troubling. It was very limited, right? It was just the behavior on the 620 video. Does that look like faking to you? It almost kind of seems like another one of these directed, almost rhetorical types of questions, because we can see it with our own eyes. So are you telling us that's fake? Them having watched the entire context of all of these videos? Does that look fake? It's just a way to test his credibility and see what he's going to say. And he said no. I think if they had asked a long, detailed set of questions about, are you familiar with the instruments, and have you reviewed them yourself, and do you have a second opinion about any of this, then maybe yes. But this particular question, no, it didn't alarm me, and it didn't even really strike me as a question about the feigning as much as just a question about Dr. Martin and his perceptions and his credibility. Serendipity, was there a Daubert hearing spelling held regarding the bridge guy photo and enhancement? No, there was not. There's no hearing like that. So Indiana, I do know from a legal standpoint, Indiana does not follow the Daubert standard. They follow what I believe is a modified Frye standard. It's their own standard. It's not one of these conventional ones. They did not have any type of hearings like that. The defense had requested a hearing like that for the ballistics evidence. They wanted to exclude it, or have to basically show some kind of validity for it. But as far as the enhancement goes, no, I don't believe that came up. I don't know if that's going to qualify as like a novel technique, scientific. It's more the type of thing that, I already know that what Judge Gold would have said is that the modification goes to the weight and not to the admissibility, as long as they, explain what they did and represent that it's still by and large a true and accurate depiction. It's just been improved so that it's more, you can get a better view of it. So yeah, I doubt she would have given one anyway, but it's the whole enhancement thing. That's a big red flag for me. It really is. Seeing those two videos, they look nothing alike. And I don't just mean, obviously this one has been stabilized and so it's turned. I mean, in that first video, the raw video, you see Abby for just a flash. And then suddenly in the stable, before the camera is back, back at the ground and back at the woods and stuff. And suddenly in this enhanced one, we got like 2 or 3 seconds of her walking, long enough to see, bridge guy come out from behind and walking behind her. It's very sus, the video. Bill Mayhem, is there a pic of the bullet at the crime scene? There are a couple of pictures of the bullet, like lying on the ground at the crime scene. What they said was that they had to remove some leaves that were on it to be able to find it, because when they found it when they were doing the alternate light source method, which is basically they shine a UV or an ultraviolet light on the area, and they have special filter glasses that they wear that allow them to see then if there's a reaction to that light. So one of the officers was watching this testing being done. He did not have the glasses on, and he noticed something was glittering on the ground. That's why the glitter came up, because it's just the description he used. He saw flashes, he saw the reflection of the light on something metallic. So they had to go in and remove some of the leaves to find the bullet. Then they photographed it, and they photographed it a couple different times. And they did not photograph it once they took it out of the ground until it got to the lab. So that's what we have, is a couple of photos of it after the first leaves have been removed, and it's still there on the ground, and you can't see the tip. You can see kind of the side and the back, but you can't see the projectile end. Brittano, if the jury acquits, how do you think others like Nancy Grace, who covered the case in a heavily biased manner, would explain the decision away? Well, they will either ignore it entirely, or they will just talk about how it's, just such an injustice for the families. That's what they'll do. They've set it up so that you're not giving justice to the families unless you convict Richard Allen. And that's what small-minded people with biased takes on prosecutions do in these types of situations. That's their thinking. It's very black and white thinking. And so there's not a lot of room for nuance, that if Richard Allen is innocent, you're not actually doing him or doing the family any favor by convicting him. You're not actually giving them justice. You're just perpetrating another one. So I don't have a whole lot of optimism for how that would be pitched on some of those large outlets. They would be surprised, and it wouldn't be the first time media has taken a stand on a case, a position on a case. They're sure it is the way that it's going to be, and then the verdict comes out as something different, and there's a lot of heads on fire reacting to that. Happened with Michael Jackson. It happened to Trayvon Martin. I mean, there's been a few. Freckle Joy, were there really sticks in Brad Weber's yard laid out to say KKK? So I didn't see that. I couldn't see these photos. I don't know. If I was afforded the constitutional standing of equality to which I am entitled with the media to be able to go and look at them myself, I would have been able to tell you that. But since I wasn't, I can't. Afton Archer, I am distraught, concerned, very scared for him. I am in Indiana and not convinced that our population is not looking at this in a way my defense-oriented brain cannot imagine. Small towns, you have done such an amazing job. It's always like that. There's always people who just kind of default to certain assumptions. Everybody has shortcuts in their thinking. Not everybody is skeptical. Not everybody's a deep thinker. Not everybody's a critical thinker. Not everybody is concerned about making sure that they've looked at a lot of facts before they form an opinion. And that's always how it's going to be. So I don't know that there's anything unique about Indiana with that. That's everywhere. That's everywhere. We got that in plenty of places where I practiced in Washington too. But I'm also concerned about him. I am. Jennifer Ferguson, don't accept candy or pens from strangers. Yeah, it caught me by surprise. I might not have, had I not been a little surprised by it, but I did check to make sure it's not a spy pen. It was not a spy pen. Marcelo, off topic, but have you seen the Mark Betterow letters on the Turtle Boy case? I have, yeah. The audacity of the DA and police officers on framing someone Doesn't surprise me in this trial either. People are disgusting. It's like this has been like the year of corruption like this coming out on a very high profile, high platform, big stage. The stuff that's going on in Canton is extremely alarming. It's extremely alarming. The Bettero letters, those are pretty damning. Pretty damning for how they went and set up a little honeypot so that they could try to charge him with crimes to intimidate him from reporting. That's what we call DARVO. Accuse somebody of witness intimidation by intimidating them using intimidation tactics. Yeah, that's DARVO. We've seen a lot of that. A lot of that in a lot of these cases. The gaslighting really is coming to light. Linda with a $5 super chat. Thank you so much with that. SF and TX. I have a federal jury summons forever more of. County jury summons on the 18th. I've been OUs about both. I would love to serve on either one of those. I really would. The federal summons, I wonder if it's a grand jury, a federal grand jury. God, I would love to serve on a federal grand jury, but that would be very, very time consuming and difficult for most people to be able to do. The grand jury is the investigative body that looks at the prosecution's case and decides whether to return an indictment. So they're like involved in the charging process. I would love to be involved in that. It could just be a straightforward federal jury trial. I mean, certainly those do happen as well. Specific federal crimes rather than state crimes. The county stuff is, kind of the meat and potatoes of criminal justice. Just your everyday crimes that you see all over the place. So any one of those I think would be fascinating. Michaeline McWilliams, have you had a chance to meet Richard Allen's attorneys? Any chances you might speak with them before leaving Indiana? You have done excellent coverage for this trial. Thank you. You're very welcome. No, I haven't really met them. They know who I am. Like they've acknowledged me. I've acknowledged them. We have exchanged words about just on a couple of occasions where I've just made comments like "good job," But no, I have not had anything even remotely like meet them, have a conversation or really anything like that. Didn't get, similar acknowledgement from the prosecution. So didn't have those kinds of exchanges with them. But yeah, maybe I will. I don't know. We'll see. I would love the chance to congratulate them. And like I've said before, just, and I mean, I do mean that, congratulate them regardless of the outcome, because they have really put up such a good fight. And they are from my perspective, they're like the positive light in this story. It's just so much evil, so much bad and ugly stuff. And these guys came in and fought for somebody that they thought was innocent, and they continued to fight even when insurmountable odds were placed in front of them. And at every turn, they're being frustrated, and they're still there putting up the fight. I respect and admire these guys and Ms. Auger, I'm using guys in plural. I admire all of them so much, and they just are such a credit to the defense profession. And I just hope I get the chance to say that to them personally sometime. Randy Gutierrez, how will we know when the verdict is handed down? Will you have to sit outside the courthouse for days waiting? We plan on coming back on Thursday Eve. So what happens is typically the court notifies the parties that there is going to be a verdict, and word gets out from there. So the news will report it. The media, is very present, if not even more of them now at this point. The people that, didn't have an interest in being here for the nitty gritty of all the trial days, want to be here for the important parts. So the verdict will be extremely important. They will report that there is going to be a verdict. I do expect, yes, we're going to have to sit outside and wait if we expect to get into the courtroom to see the verdict being returned. So we are expecting that and kind of preparing for that. And hopefully it doesn't take long, but you just never know. Paula Siemek. Vasquez gave a talk at my university and answered very eloquently and thoroughly, in my opinion, loads of questions from skeptics. I don't think she changed their minds at all. It's a real shame. Yeah, Camille Vasquez, you know, she knew that case. She knew the problems with those stories. But yeah, it's just that people, once they're entrenched, I mean, there's studies on that. Facts don't matter. If people are really entrenched in their opinions, a lot of times facts don't matter. And not only do they not matter, they can sometimes be counterintuitive. They just make people even more entrenched. And some of that is those, psychological processes we've talked about, these defense mechanisms. Just ignore and push that back and get angry about it and make all other kinds of justifications and stuff. Our minds are they're just so peculiar how they work sometimes. We're not necessarily evolved to be great discerners of truth. We're just evolved to develop an understanding that we can have confidence in. And so when we are threatened with something that could undermine our worldview, it is threatening, and we take it as a threat, even if it's right and our worldview is wrong. Emil, thank you. You're very welcome. My pleasure. Esnir, Andrea, in your observation, where do the victims' families stand in terms of Richard Allen's guilt, and have they reacted to the multiple failures on law enforcement's part? Thank you for all your work. I don't know, because I am not trying to scrutinize the victims' families and analyze them. That's not me. It's not who I am. It's not what I do. I'm not going to try to armchair psychologize them. I don't know. And I want them to have the space that they need to express whatever it is they're feeling without worrying about, is somebody over here, trying to judge my reaction. They're in a unique situation in this trial. They have suffered a unique harm in this trial. They have a unique interest in the trial process. And so I don't want to inject myself into that or interfere with it. So I'm not focusing on the victims' families at all. I don't know. I have no idea how they feel. I have not looked for or seen any type of reaction. Stadeka, what are the defense's top 3 arguments for closing, in your opinion? And 2, does this court allow the jury to review testimony? Answer to number 2 is no. The court does not. They were told at the very outset, you got to take your notes because there's not going to be a transcript. You're not going to be able to refer back to it. So you're going to have to rely on your memories and your notes. The defense's top 3 arguments for closing. If they had a good case, they wouldn't have to be this shady about it. I think that's a very important point. If they had the goods, that's all we need. But we've seen them have to mislead us, have to, gaslight us about what the evidence actually shows. So I think that's a very important point to make. The opportunities that the state had to get answers to many of the questions that all of us, including the jurors, have had, that they either squandered, or because of ineptitude or worse, they lost. I think that's very important to point out, because the state has the burden of proof here. They're the ones that are entrusted by the public to go out and get the evidence to be able to make this case. And they betrayed that trust badly betrayed that trust here. Top 3 argument. There's just not anything that we can rely on to establish that Richard Allen is bridge guy. It doesn't fit. The fact that the eyewitnesses describe somebody completely different, The car that's at the CPS lot is not his car, and there's no other car there when his car is supposed to be there under their theory. Nobody sees him. Nobody identifies him. And all they have is this little black smear of a car, on a camera nearby that could be one of, sounded like 70 or more cars registered in this area. So, you want to talk about not having a nexus. To me, those are the real strong points. The rest kind of follows from that because the confessions, if you can't put him at the scene, it's almost like his confessions don't even really matter. It just kind of emphasizes, these just lend weight to the fact that these are not reliable. We heard a lot about the circumstances and why they're not reliable. But if you could still put him at the scene really strong, then that would give the confessions potentially more weight. But you can't even put him there. And the people that you've relied on to say that it's him, they don't describe anything like him. So I think those are the three most important things and are probably what I would want to focus on. The shady stuff, the shady behavior, call this out. It's just there's no need for that. If you've got a good case, you should want to show us everything. And you're clearly not doing that. And you're literally turning around and trying to blame us for not doing what you have the responsibility to do. The investigative failures, the fact that the questions that would help us answer this, they are the ones entrusted with preserving and safekeeping that information, and they failed in that. And that falls on them, not on Mr. Allen. And then just objectively, he doesn't match. He doesn't match. The rest of it, I think, can flow from that. The crime scene doesn't match their theory. The timeline doesn't really match their theory. The headphones certainly don't match their theory. Run the world. Thank you, Andrea. You give me faith in humanity. Well, I have faith in humanity because of a lot of people out there like you and so many of the supporters here. We got a lot of good-hearted, open-minded, caring people. And I'm one of those people that believes that most humans are fundamentally good. We're flawed in many ways, and everybody makes mistakes and everybody sins. But that's part of our role on this earth, is to just try to comfort each other and help each other and uplift each other and, help each other be better. So I really appreciate having this community here that helps me do that. Holly Clay, who is Elvis? What did he admit to and when? Elvis Fields, the way to look at this is to go look at the Frank's memo. Elvis Fields is an individual who has some associations with some of the Odinists who were like the collateral suspects in this case. And he made very incriminating statements. He confessed to his sister shortly afterwards, actually two sisters he confessed involvement in. He was interviewed by police and he made a statement to the effect that if my spit was found on one of the girls, but I could explain it, would it be a problem for me? So a rather odd and incriminating type of thing that one would normally expect a law enforcement officer to view as consciousness of guilt. So that's Elvis Fields. He's the one with the most really direct connection to the crime in the whole Odinist theory because of the fact that he confessed to it. Jeremy Morton, thank you again for this. Yesterday, you got a vote to be president as I needed a write-in name to make sure I had it marked. Oh, that's pretty cool. I wonder if there's like a record of that somewhere I can go hunt down in the returns, Maybe I can and put that on like my Twitter banner or something. Suyan, about the confessions the jury have, is all we have just written testimony? In my opinion, state have not proved guilty. They don't have him on video saying anything. Nothing. These are all reports from witnesses, from guards saying he said stuff, from Dr. Wallace saying he said stuff, and then, writing it in her notes that he said stuff. It's all he said. None of it seen with our own eyes. So That's going to be important, I think, as far as how much weight those confessions get with the jury. Scan, ma'am, how is it they presented not one iota of odd or perverted searches from this man's electronics, yet a search of the girl's phone exposed a plethora of perverts? How in the hell could that be? I mean, this didn't come out at trial, so we don't know. This is the whole absence of evidence is not necessarily evidence of absence. The fact that it didn't come out at trial doesn't mean that it didn't exist. It could mean that there's stuff there that for, a variety of reasons didn't get exposed. That said, I would expect if their theory of the case was this was an assault motive, we'd have heard about it if there was something on his. On hers, it never came out at trial. So I do think that would have been potentially significant, but goes to third party culprit, not allowed to go there. Afton Archer, she's very angry over their competence and commitment and perseverance. Clearly, they made it too hard on her. Yeah, I mean, I gotta wonder. I really do. It's like the more they stand up for him, the more that they're, she's going to punish him for it. I think the safekeeping order is a really good example of that. You're going to try to act in his best interests. I'm going to shoot that down and not just deny it, but call you dishonest. I'm going to attack you for it. She wants to kind of, make them question whether they should keep fighting. That's what I see. The ugly doctor, is it considered insulting if, say, you or lawyer Lee or Bob were to send the defense team tips? And I agree, sad, but avoid police contact if you can. Unfortunately, it's not safe. I mean, it's not rude to send tips, but I wouldn't. It's not my place. I'm here. I'm findable. If they wanted me, they would ask. I'm not one that's going to force my, push my unsolicited thoughts on them because they don't know who I am. They've never seen me in trial. They don't know, they don't know me from Adam. So it's just not something that I would do. Not necessarily because it's insulting, but just it's really not my place. Mendy, Allen County lawyers, which of you will run against Judge Gohl? She has won because she is unopposed. I will organize door-to-door volunteers for you. Here's the word. Word is out. 2026. She's got to rerun. Start thinking about it now. It's not too early. Start getting your campaign committee together. Start laying your plans. Start getting your resume polished, start making those doing that networking, making those connections. Yeah. Somebody should run against her. A lot of people are going to remember this trial. What's in the world with a $2.99 super chat? Thank you so much. Velveteen Bilby. That's a fun name. Is now a YouTube member. Jackie Rice, did they test the cell phone for DNA? I recall that they said that they swabbed it. I don't actually recall them giving specific testimony about that. Let me check. I remember now that was day. Okay, Stacy Bozanowski. Let me just go ahead and go through the notes because this is why we took them, right? There was so much stuff that they tested, a lot of results. Swabs from the phone found under Abby. 2 swabs. They did no serological testing. There was no blood-like staining. There was both a presence of a mixture. Could not assume the number of contributors, so no conclusions were drawn. They got a DNA mix from the phone, and it was either a low quality or low quantity mix, so that they were not able to figure out how many people had contributed to that mixture. That's all that they got from the phone. 1,000 Julys. Nordic Phoenix and AB, I am also willing to be on a community group to hold others in positions of power when they are abusive, directly or by proxy to those with mental health conditions, and are eager to dismiss and discard their victims. Thank you so much. Great. Let's build an army. Why not us? Thank you so much for stepping up. These are important issues. Kathy Wright, he has to be found not guilty. This is shady, dark, and desperate. My heart breaks for Richard and his family. I am praying for a not guilty verdict. I really am. I think that that is justice in this case. I hope that they can deliver that. Mendy, line update. We have a line sitter and our number 16. I am skeptical about tomorrow, though. The media have multiplied and are behaving like brats. Boo. Yeah, that's unfortunately not a surprise. You know, they've been handed everything that they, that they wanted, and it's still not enough. They get more seats and it's still not enough. Can't say I'm surprised. We'll see. 16 is right on the margin of getting in the door. So hopefully we don't have, line amoeba situations tomorrow. Starlight Selenite, do you know why Elvis was cleared? Thank you. As I recall, I can't remember because I'm confused about this part of the case. It was either him or Ron Logan that was like, they went to the hospital in Muncie and they just basically said so, that they were there that day visiting a disabled veteran or something. And there was like no follow-up on that. They didn't, as far as we know, check with the hospital or anything. They just went, okay, wasn't there. As far as I remember, that's why he was cleared, but I could be confusing that. I need to go back and read the Frank's memo again, because it's been a while and there is a lot of detail in it. Cookie Harris, despite work sending me on an ironic hot mess express this week and the scenic route from Texas to Boston and now Indiana, chaos can saturate life. Indeed it can. But my pens, those bad boys are perfectly and meticulously organized. For that, cheers to us pen enthusiasts. Cheers to you, Cookie. I have found myself truly, truly wealthy in pens. And I'm very grateful for that. Peggy O, any jurors that concern you? Nice to meet you, by the way. Very nice to meet you too. Always good to put a face with the name. Not really, not at this point. There was one earlier that had concerned me, but I am not concerned about that particular juror anymore. I feel that I've seen a shift in just demeanor, overall presentation. That largely coincided with the videos. I think it largely coincided with the videos. There's a couple jurors that I can't see them, so I don't necessarily have a good read on them. I don't really know whether to be concerned about them or not. I don't, like I said, there's only a couple that I feel like I have some kind of read on, and it's just because they have been more expressive than the others. Most of them have been very deadpan. It's hard to get a read. Miss T, iPhone 6 has IP68 waterproof tech, FYI. Well, that's interesting. Yeah, I've never had an iPhone, so I'm just not familiar with, the generations and kind of how the technology is improved and stuff like that. Certainly, I know that the modern iPhones have a lot of, they're waterproof, but I don't really know anything about when that started. So that is interesting if that's the case. I do wonder if 12 people on the jury, surely one of them had an iPhone 6S at some point, maybe. I don't know. LM, see you next Tuesday. Well, I'll assume that's not at me, but I will appreciate that. Brandy Doot, I feel like I could have done a better investigation myself, blind. I'm experiencing dissonance over how wrong so many things surrounding this have been. I communicated with Rick through GTL. He responded, oh, that's very interesting. So the GTL is that, it's Global Tel Link is what the company used to be named, but that's the tablet. They have different ways of being able to communicate through that. So that's very interesting that he responded. It sounds like he appreciates the human contact. Nikki Mick7, if a juror asked if the stick placement was ever thought to be symbolic, do you think that question be asked? I believe it's something like that was. I'd have to go now back through like all my notes, because the jury questions are they're just so interspersed with everything. I do feel like they asked some questions about the sticks. I don't think it was about symbolic. Like it wasn't that direct. Yeah, I don't have anything that's like a note I made, real quick. So yeah, I vaguely recall they had asked something about the sticks, but I just don't remember what it was. Charlotte ASMR, if I were on this jury, I'd be very upset to learn left out info after the fact. I get need for objectivity, and it's egregious in this case, but in general is too much kept from juries. Love your coverage. I mean, that's a whole philosophical debate. I see this one from both sides, because I'll just say straight out, where this comes up most often is with people who have like sex crime stuff in their history, because there is such a strong tendency to see that as like a persistent type of issue. And if you've done it before, you've almost certainly done it again. And it's very hard to separate that from the fact that you can have people that are bad people that are still not guilty of the thing that they're charged with. And so it's a hard distinction to draw between how do we make sure that we're not biasing the process, but still being fair about whether we're evaluating the person's, guilt for the specific crime that they're charged with. And it's just one of the principles of our system that you don't convict people on what you think is propensity. People tend to do this, or people probably did this, probabilistic kinds of things. You don't do that. You really have to have the evidence that they themselves did it. And the reason why it's philosophical is because that's the whole foundation of this idea that it's better for 10 guilty men to go free than for one innocent man to be imprisoned. And not everybody agrees with that. Not everybody agrees with that. Some people are far more comfortable with the innocent getting caught up in the net, as long as we get all the guilty people. So it's difficult. I don't think that the line was drawn in the correct place in this case at all. Like not even close. And especially with stuff like third party culprit, I understand the reasoning behind it. No, you shouldn't be able to just like smear and throw a suspicious light on anybody for no reason. But it also shouldn't be a really high bar. Because if your evidence is trash and your accusation is trash, it will come out at trial, and the jury will judge you accordingly. So at the same time, there's a potential, if you're in a high profile case like this, if Richard Allen can get on the stand and say, I don't know, Donald Trump did it, then there's going to be headlines, Donald Trump accused of murdering girls in Delphi. And and so that's going to affect those people as well. So it's not black and white. These are difficult issues. You really do kind of have to take them case by case. I don't think the line is drawn in the right place here, but I also very much understand why, jurors finding out more information after the fact, that could be very upsetting, because it's an important job that they have and they take it very seriously. And I can see how a person might feel like I let people down. I didn't do a right job. I was complicit in an injustice. I can understand that. Tilly T, fun start after trial spa day. Oh man, I'm going to need it too. I feel like my eyelids are going to They're going to like swell out of my face. That's okay. We'll get there. Kate's Meow, did defense ask for an arrest warrant for Elvis Fields today, if nothing else, to get it on record in the event of an appeal? Yeah, they did. I mean, this is really just making the appeal record. I do think they would have liked for the warrant to be issued. I mean, I think they knew it wasn't going to, but yeah, they wanted to get him on the stand and to be able to ask him questions and get him on record. It's only from their perspective, if Rick Allen is innocent and Elvis Fields is a potential, strong suspect, then that's only going to help him, you would think, for purposes of appeal, for post-conviction, and ultimately for justice for Abby and Libby. If he really does know more than he's admitting to, and he decides maybe today is the day to admit it, I think they would have really liked it. But that was never going to happen, not with this judge. Kiernoth, now with 47 soon to be in office, do you think there's a chance of reforming federal laws to allow cameras in court? After this case and the kangaroo courts going after 47, the feds need transparency. It's going to have to come from the courts, and the courts have historically always been extremely resistant to cameras, the federal courts. So it isn't really something that 47 can have a lot of influence over, other than just like he can't do it himself. He can't. It's a separate branch of government. He can't tell the courts how to run their business. That would create a separation of powers problem. But he can certainly advocate for it, and he can, express his position on why that should be the case. The Supreme Court has a lot of insulation from political pressure. So in many ways, it doesn't matter. They can ignore him. They have lifetime tenure for as long as they want it, barring high crimes and misdemeanors that could lead to them being impeached. So it's ultimately up to them. But it is a situation that needs to change. There has been a pilot project underway. I think it's been a couple or a few years now. Not a lot of courts are participating in it, but some are. And so they are like slowly testing out this idea of having cameras in federal courts. I'm pretty much, and I pretty much was after Delphi heard, cameras should be in every court. Cameras should really be in every court. I mean, that's an exaggeration. No, I don't think cameras should be in there for, I don't think cameras should be in there for juvenile cases. I think people who are kids should still get some protection, get a little bit of room to be kids and make mistakes as kids. I don't think they should be on TV. I don't think they should be, being tried as adults either, but that's a whole different issue. Things that are very sensitive, like, conservatorship, guardianship. I was not somebody who had a real problem with like the Britney situation, with that being confidential. It's very private. If she wants to reveal it, okay. But, until she did and was kind of taking those steps, I have no problem with that being out of the public eye. That's just very serious, very personal, basic dignity kind of stuff. So there are definitely exceptions to that. But as far as criminal trials, no. Every courtroom, because we saw Delphi Heard made it very clear. Emily D. Baker called it out. Very clear. You couldn't count on the media to report it accurately. You just couldn't. And some of that is very willful. It isn't always, but a lot of times it is. They've got their narrative that's what they're going to push. And their coverage gets skewed to support that. And I think we see some of that here with some of these outlets here. Peggy O, did you hear any testimony pertaining to cast analysis of timing events? There was absolutely nothing about cast. The only time cast came up in the entire trial was when Jennifer Auger was asking about, she was asking the Stacey Eldridge about the potential, like cast did drive tests. They got a lot of drive test data to be able to evaluate signal strength from different towers in different parts of the world and stuff like that. That came up in the context of this, possible theory, which does seem like a plausible theory, that the reason why Abby's phone or Libby's phone went dark is because it just lost tower. The tower was weak for whatever reason, bad signal in this area, and it just lost signal. Nobody ever went to look at the tower records. Nobody ever asked for a drive test. That's the only time that CAST came up in the entire trial. K, too many people convict either as jurors or in the court of public opinion based on emotion. I think there is a lot of that, especially with a crime like this. This is a crime that causes emotional reactions. It's very horrifying. And so, once they come out and they say we've got him and it's it, and his mugshot is out there, people are already, they've already got that association, and now look at him and he looks so scary and obviously he did it, and you're just able to kind of build that up in your mind. I think that's pretty common. Miss Deanna, appreciate you so much. I may have missed it, but when do you think this will go to verdict watch? P.S. Hopefully you got to try Biaggi's while you were in Allen County. I did not. I barely got to be in Allen County. Since things have gotten done so much quicker than we have expected, I may have time to actually spend a couple extra days here where I just get to explore Indiana, which I would really like to do. It's one of the things I was looking forward to about being here. This is a part of the country I've never been in. I'm very much I have wanderlust. I love to see new places. I love to travel. And so, yeah, I wish I could have spent more time in Allen County, but I didn't. So I will take note of Biaggi's. This will go to verdict watch tomorrow afternoon. We expect the jury to get the case tomorrow afternoon. And then at that point, we will be waiting. We will be waiting. Jilly Bean, does the jury know anything about Elvis? They do not. Not a thing. His name has not been allowed to be dropped in this case. Aries 414. So you're our expert witness in this trial, and we are all so lucky to have you. Thank you again. In all your years as an attorney, have you ever heard or seen of a more botched, biased shit show than this trial? Just awful. I have not. Nope, nothing like it. I've never seen anything like it. And just the convergence of all of the things that I've never seen before. I've never seen police corruption, that I'm calling it corruption because it's dishonesty on just such an obvious scale. All of these, the videos missing and the lying about it and the skewing the statements that are made and the gaslighting about what we can see with our own eyes on the interrogation. I've never seen anything this extreme. I really haven't. Like most officers, even the bad cops, they have some kind of self-awareness about that. Like they understand how they're coming off. These guys don't seem to have that at all. I've never seen anything like that. The judge this extreme, never seen anything like this. I've seen bad judges. I have never seen anything like this. And the treatment of a pretrial detainee in solitary confinement, never seen anything like that ever. Never heard of it. Wish I never had. All of these things happening in one case, unbelievable. Unbelievable convergence of circumstances. Never seen anything remotely like it. Berries Hospital indeed was Elvis Fields and R. Abrams. Their excuse for no phone data was the hospital shuts it off because it interferes with their machines. Thank you. I forgot about that bit. Yes, that the hospital supposedly has blockers. How many people have ever been to a hospital, spent time in an ICU with a loved one, needed to communicate with people that maybe like the last moments are coming, things like that? Almost everybody. It's like such obvious bullshit. That cleared him. That cleared him. What do we think of that? What do we think of that? Lots to Learn is a new YouTube member. Welcome to the channel. Appreciate your support. Shelley Wilson, I feel goals increasing of press seats is direct rebellion to your filing in the original action. It could be. It could be. We did get a lecture. I told you the other day we got a lecture about being silent, and I've told you many times. And from now on, we get tapped. So this morning when we came in, the bailiffs told us there were changes. They didn't specifically talk about changes to the number of seats and so forth, but they did say that there are changes, and that this is coming straight from the judge, and that if we are whispering, talking, anything at all whatsoever while court is in session, we will be tapped on the shoulder and told to leave. No questions asked. There will be no arguing. So not as many of us are allowed in the courtroom. And implication being, yeah, these changes are coming straight from the judge. So it wouldn't surprise me because that's just the kind of spitefulness that she's shown from day one in this case. Brandy, do it with a $99.99 super chat. My goodness, Brandy, thank you so much. You are so generous, and I really appreciate it. MZ Batman, thank you, Andrea, for covering this case. Will we ever get to see Richard Allen's interrogation videos? They are public record. They are public record. We can technically request them now. I mean, there's nothing that says like you're not entitled to get them until the trial is over. We just won't, as a practical matter. But yeah, people can and should request them. I'm thinking about that already, getting these exhibits, seeing if I can maybe get a hold of these exhibits and just go ahead and publish them on my website. Like I did with the unsealed stuff from Johnny Depp. I still got that up on my website, even though it's like everywhere now. It's in a bunch of places. I don't even really need to keep it anymore. Yeah. Getting transparency. It is public record and we should be able to see it. Brandy Duke, girl, shut her down. Get your rest. You have been refreshing AF. Thanks for doing you publicly. You're their real MVP. Thank you, girl. We are just about at the end here. I do. I feel like when you guys spend your hard-earned money to like show me your comment, I take that seriously. I really do. It matters to me. I don't care if I don't care if you're $1.99. I don't care if it's just you've taken the time, the resources, the energy. I want to honor that. Deborah Rogers, are there any SCOTUS decisions to protect a conviction based on circumstantial evidence only? No. In fact, the case law is that the circumstantial evidence is legally sufficient to support a conviction. You don't have to have direct evidence. In fact, most cases you really don't, because direct evidence is typically going to be you got it on video, or you got an audio recording of it happening or something. You have eyewitness. Or you have a confession, like a good confession. You don't have those in every case. A lot of them are circumstantial. So, nope, the law allows conviction based solely on circumstantial evidence. Theory Neutral, just got off work and off to bed, but came to ask if you could please record as much of the D's clothing as possible, and please be careful. Crazies conspiring everywhere, and yes, likely killers on the loose. I am definitely being careful. I have taken some steps to just be a little bit more precautions about, where I'm at and when and stuff like that. I don't leave my bag unattended in case somebody is inclined to slip a little something in there. Doing my best to stay alert. I'm pretty good with my situational awareness. Always kind of have been. So doing my best. But yes, I'm going to do everything I can to get as much of the defense's closing as possible. I hope that they don't speak super, super fast to try to get as much as they can out in the time. But I don't expect them to pause just for my benefit either. Okay, guys, time for today's notepad count. We only used about a half a pad today because we didn't have that much to do. Yesterday, I missed the notepad count. We did do a full notepad plus one page yesterday. So if we estimate out the couple of days or so where we only had about a half a page, I'd say we're probably in the ballpark of about 17 legal pads right now. 5, 10. Yep, we got one a day. So probably about three to 4, maybe 5 at the most half days. So 18 and a half would be where I'd put us at. A lot of notes here, guys. A lot of notes here. Really appreciate all of you. Thank you so much for your support. Maligator, will you have a spot tomorrow? So far, I'm supposed to have a spot, but I am at number 16. So I am a little bit on the margin because things have a tendency to get chaotic and sometimes change as we get closer to the morning. At the same time, sometimes people do just put their chair and then don't show up. So it's a bit of a flexible situation, but so far things are looking good for me to be able to get in. So continue to keep our fingers crossed and hope that that will work out in a way that's fair for everybody. Mendy, is it normal for swabs to not have much DNA on them? It seems there was so little evidence discovered from the scene. I mean, the best source of DNA evidence is always going to be blood or body fluid. And if you're just in a contact situation at a scene, unless you have somebody that is a particularly high shedder, and it doesn't seem that unusual. This isn't, sex assault, something like that, where you'd expect there to be rich sources of DNA present. This wasn't a mutual combat situation where you might expect, blood, body fluid, things like that to be exchanged or smeared around or whatever. So if it's just a touch DNA situation, I can't say it's really that surprising, especially just given the possibility that, people can wear gloves and stuff. So nope, does not necessarily seem that surprising to me. Starlight Selenite, you are such a good person, Andrea. Thank you. Well, that's very kind of you. Very nice thing to say. I'm going to take that off to my sleepy time right now. It is getting a little bit late, so I want to make sure to not add too much to my sleep debt. I did get a nice nap this afternoon, but could always use more at this point. The Iceman 101418, can a judge be guilty of a Brady violation? No, it's just an obligation on the prosecution. I feel like so much exculpatory evidence has been excluded from this case. The third-party culprit exclusion alone should be enough for an appeal mistrial, in my opinion. I agree. It should be grounds for reversal. I think it's an absolutely terrible decision. It's unfair to him. It's he's got a right to present a defense, and they have taken that away from him. So I think it's a violation, and even if he is convicted, that he would get a retrial. But as I've said, I don't think he's going to be convicted. I think worst case scenario here is a hung jury, but we'll see, because you never know what a jury is going to do. Thank you, everybody, for being here. Thank you again for your support. I always do appreciate it so much. I value your questions. I value our conversations. I value your insight. I learned so many good things here. Like, gosh, the brain power in this chat is really amazing. It never ceases to amaze me. Every trial, we get people coming through that have very specific, technical, detailed knowledge about things that are material to the issues the jury is being asked to consider. So I just consider myself so fortunate to have folks like you, out there watching my content and taking an interest in this case and offering your insights. Very, very wonderful situation to be in. So very grateful for all of you. Grateful to the line sitters. Grateful to the mods, Phil, the Gilbert Vinbigs, bar hopping with the Burkharts, new show featuring at Forensic Führer. Yeah, we could see maybe. I'm not much of a drinker, honestly. I'm really not. I don't bar hop. I'm too old for it. I can't do it anymore. Costs me too much of my sleep and my sleep quality. Rochelle D. Andrea, I watched an episode of Paranormal Nightmare in which girls are heard screaming in the woods at night on a spirit box 40 miles away from Delphi, yet so quiet in Delphi. That's disturbing. That is very disturbing. I don't like it at all. Don't like it at all. All right, guys, I'm off. I'm going to cut, draw a line. We are over. If you send in another super chat, I'm not looking at it. So I'm going to get my sleep, keep my fingers crossed for the line tomorrow. Look forward to these closings and just continue to send all of my good, best energy, my wishes for justice, my prayers, everything that you do. Send it to this jury that they do justice. Whatever that means. Whatever that means. It's just important that, the jury have that support. It's a very difficult task that they have. So appreciate all of you so much, and I will look forward to seeing you tomorrow, hopefully with closing arguments to report. I'll see you then.